felon who doesn't have their civil rights restored. We know that the board asks routinely for evidence that income taxes are paid. Anyone that has gone through the character and fitness screening, and any member of the public would be probably astonished to see the broad range of issues that are asked of applicants, including whether they bounce checks. And so the question I have is, does that normally take place? There's some certain things that you need before you can take the bar exam, but I assume the character and fitness, depending on when it was asked for, occurs either simultaneously before or after the bar exam. That there's two aspects. One is, graduate from accredited law school, or three, you graduate from accredited law school. Did you pass the Florida bar exam, and do you pass character and fitness? Are those the three parts?
Yes, ma'am.
Okay, so where does, whether you are a citizen of this country and either able or not able to be employed in the state of Florida legally, where does that fit in into the to the inquiry that the Board of Bar Examiners makes?
Well, do
you understand my question?
Yes, ma'am, I do. And as Justice Lewis pointed out, there are certain status questions. For example, someone that's a convicted felon, someone who's a disbarred lawyer, someone who's a suspended lawyer in another state.
Are they then not able to take the Florida bar exam?
They are not able to apply unless they meet certain criteria.
So this was determined to be one of the criteria in which, if you didn't provide it, you couldn't even get to the next step of taking the bar exam.
Well, I don't think the board felt that it had the authority to say you can't do this if you can't provide this documentation.
Okay, but let's now go. Maybe there's a waiver estoppel, but this court isn't in the position of waiving an estoppel.
Right.
What is the bar examiner's position on whether what does the license to practice law, which is what would be granted or not, mean when this court authorizes that somebody is licensed to practice law in the state of Florida?
It means that you are designating that person as an officer of the court.
And to do what? What are they practice law? What does that mean?
That means to be able to appear in Florida courts. It means to provide legal advice within the state of Florida.
Can this individual, under the laws of the United States, do that?
My understanding, as things stand right now, there are limitations on what he could do. Certainly, my understanding is that he has applied for the work permit that has recently been provided for by the Department of Homeland Security. If that's granted, then he certainly would be able to perform those functions.
But at this stage, he cannot be legally employed in this state. Yet if we gave him a license and he chose to pay no attention to the federal rules, he could open up an office and actually have people come in, give them advice, take money from them, etc. If we give him a license, is that correct?
Yes, ma'am. I don't want my answer to be suggesting that I think he would flaunt the law like that, but I think yes.
I'm not saying that he would. I'm simply saying that is a possibility.
Yes, ma'am.
I don't understand. I guess what I don't understand is it seems to me that in California, the bar examiners decided that the person who was in a similar situation passed everything, character and fitness, and they admitted that person, and then the problems occur.
I think they recommended him. I don't think he
recommended it to the court, and then the problems occur. Here, the board is what advice are you asking us for? This is my problem. It seems to me that if somebody is at this point illegally in this country, just like somebody who is not paying their federal income tax if they were required to do so, the board would never recommend that person for admission to the practice of law. So what is the board's position on this? You're asking us for advice, but you're the experts with looking at thousands of people every year. What is the appropriate character and fitness analysis for this particular individual.
The board has not made a recommendation one way or the other on this issue. And it's a contentious issue in our society, as you all know. The board was not able to reach a consensus.
But I feel like that's what's happening here. It's a contentious issue, but we're really here on a very narrow question, and it puts us in a position. I know there's lots of views in the public, but this is really isn't this a narrow issue as to whether this person would meet the character and fitness requirements, that the rigorous screening requirements that the board demands of every applicant that comes before the court?
Well, actually, the way the question has been presented to the court by the board, it's not really about this applicant. It is a broader question. And I guess to rephrase the question is, does the court want to adopt a bright line rule that if you are in the country without proper documentation, you cannot be admitted to the bar?
Let me ask you this. Yes, has the board considered the implications of Title VIII, Section 1621 for that question?
It was not really brought to the board's attention in their analysis.
Could I ask why? Do you think that law doesn't have some possible relevance to this question?
Yes, sir.
And the responsibility of the board and of this court? And doesn't this court have an obligation to follow the federal law to the extent that it's applicable?
Oh, yes, sir, without a doubt.
And hasn't the Department of Justice taken the position that that federal law would preclude the issuance of a license to practice law in circumstances such as are before us?
Yes, sir. In the California case, the federal...
Is there any material distinction?
The way you get to the court's authority in California is a little different from the way we get to it in Florida, but the bottom line
we're
is
sitting
the
right
same.
here. I think we're using appropriated funds as we sit here this morning.
Yes, sir.
Wouldn't you agree?
I agree. And according to the Department of Justice brief in the California case, they said because this court uses appropriated funds to operate and the license to practice law is issued by this court, then therefore that federal statute...
Does the board disagree with the analysis of the Department of Justice?
The board has not taken a position on that.
Why not? Isn't that your responsibility? I'm not talking about your individual responsibility,
Yes, sir.
but the board's responsibility. They punted.
Well, for one thing, I'm not sure that at the time that this was being discussed and the decision was made to refer this question to the court, that the board was aware of that statute. And once they became aware of it, we did file the supplemental authority to provide you with the Department of Justice brief so that information would be available to the court.
Have you? I noticed we've gotten a lot of filings from the California case, but the Department of Justice has not filed anything in this case. And I again understand you're only. I mean, you're not only, but you're advocating a position and you are representing the board. But these are difficult questions. Has the Department of Justice been consulted by the board subsequent to the filing of the brief in California?
No, ma'am. My understanding is their filing of the brief in California was at the invitation of the California Supreme Court.
So that's something we could do here?
Yes, ma'am. You certainly could solicit. In fact, I believe in the board's reply brief, we even mentioned the possibility of approaching certain organizations with regard to whether you would want to request that.
Have they done that in the New York case? Or has the New York case progressed to the point of briefs being filed?
My understanding of the New York case is it actually hasn't been filed in court yet. That there was some publicity that there was an undocumented immigrant that was working through the process in New York, but I'm not aware of an actual court case there.
Now, you've asked for this advisory opinion. I see you're in your rebuttal, so I'm just going to ask this. It's been in effect since 2008, the rule that requires prospective lawyers to submit evidence of whether they are citizens of this country or lawfully in this country. Since 2008 until the present, is this the only person that fits into this category, or has there been rejections of other people, or what's the status?
No, ma'am. This is the only person who has approached the board proposing to apply for admission to the bar that was not able to provide the documentation.
So although this is obviously, for many reasons, high profile, it really affects only this one person.
Yeah, I could speculate as to if there were people that might have thought about applying, didn't have documentation, and saw the requirement and decided not to. But obviously, I don't know if there's anyone that fits that category.
You're in your rebuttal.
Yes, sir. Thank you.
May it please the court. I'm Talbot Dallenberg, here with my partner, Patsy Palmer, representing the applicant, Jose Godinez, who has now done everything that the rules of the Board of Bar Examiners require of him. He came to this country when he was 9 years old. He learned English. He went to school. He graduated as valedictorian of his high school class in Tampa. He became an Eagle Scout. He went to New College. He did not have access to Bright Futures or to federal student loans. He made his way through New College, applied to Florida State University College of Law, revealed the fact of his undocumented status, did very well in law school, as he had done in high school and college.
Let me just stop you there. When he applied to FSU, to the law school, you said he revealed his undocumented status to the Florida State University?
Yes.
And at that point, was there any discussion about, well, you can get into the law school, but there really hasn't been a case of an undocumented alien being admitted to practice law in the state of Florida? And again, we don't really have the record in this case, but it seems to me that there is some, the question really is was there some estoppel along the way? You're not suggesting that when FSU admitted him that they were making any representations as to whether he would be admitted to practice law?
No, Your Honor, we're not. Our submission is simply that he attended an ABA-accredited law school. He did that after a full disclosure of his undocumented status. He wrote an extensive essay that's a part of the record, part of our appendix.
Up to the point that the executive order was issued recently, could this applicant have been deported?
In theory, Your Honor, but if we go back and
well, not in theory. I mean, under the law. Under the law, was he illegally? Let me just say. Let me finish. Was he illegally in this country?
Well, he is undocumented, Your Honor. He entered this country legally, and right. That becomes very important.
I'm asking you, did he remain here after he became 18 illegally?
He remained here without documentation.
Was that under the laws of the United States? Was that illegal?
It was, Your Honor. It wasn't illegal in the sense of being anything criminal, but it was not in compliance with the law, and so he did not have the documentation. Now,
is there any reason posited in this record why, from the time he was 18 until now, which is some 6 or 7 years later, that he has never attempted to gain legal status?
Yes, Your Honor. It was not available to him.
So he could not become a legal resident because...
That's correct.
Why?
Because the law did not allow him. He could leave this country, stay out of the country, I believe, for 10 years, and then apply to re-enter the country. But once he's overstayed a visa, an act he took when he was 9 years old, he now is subject to federal law that says that he may not seek citizenship without leaving the country and later returning after a long period of time.
Would you agree that we cannot decide this advisory opinion based on a waiver or estoppel? You're not asserting that because the Florida Board of Bar Examiners waived the requirement of producing documentation that somehow the court is bound to then accept him into the practice of law?
No, Your Honor, and let me make a larger concession than that. We believe that the Florida Board of Bar Examiners did have the authority to ask the question. about what his status
They
was.
did have that authority.
Well, we think they did, and we think they had the authority as part of their inquiry into character and fitness. But we do not think that the board has authority to have a bright line test saying that he cannot be admitted to.
Let me ask you about the same thing I asked the counsel on the other side about, and that is the opinion of the Department of Justice on Title VIII, Section 1621, and its application circumstances like this. Do you disagree with the opinion of the Department of Justice?
Your Honor, I agree with parts of it and disagree with other parts.
Tell me what you think is wrong about it.
Your Honor, first of all, let me point out that the situation relating to the applicant in California and this applicant are entirely different. This applicant is now, by the terms of the June 15th, 2012 executive, not executive order, but declaration of policy by the federal government, it now has a pathway to citizenship, not to citizenship, but to residence without challenge, has a pathway to a work permit.
But if I understand that correctly, that's just what that policy is just an expression by the executive.
It is.
That they're going to exercise prosecutorial discretion, essentially,
Exactly.
and not go after the people and to deport them who fall in that category, or otherwise enforce the laws against them. Is that correct?
Your Honor, that pathway is laid down in that determination.
But that's not a law.
It is federal policy, Your Honor, that allows him to be in this country without challenge and without threat of deportation, and allows him to get a Social Security number, allows him to get a work permit. So the policy laid down on June 15th, 2012, we think is an important policy that applies to this applicant, does not apply to the California applicant. But, Your Honor, I'm not trying to filibuster your proposition. I think we need to honestly look at 1621 and ask ourselves the questions.
Is there a limitation on 1621, a time limitation?
I'm sorry, Your Honor?
Is there a time limitation on that? How long will
this...
this...
No, I'm sorry, Your Honor, there's not.
Excuse me?
No, it would still apply. So 1621, I think Justice Kennedy is quite correct that 1621 would apply today. And so we need to look at 1621. Look at its terms. What 1621 says is that you may not give, that an agency of the state may not give a professional license. Is this court an agency?
Well, there's the other part about the use of appropriated funds. As I made the point earlier, I think we are using appropriated funds here, and ultimately, this court is funded by appropriated funds, and it's ultimately our responsibility to issue the license to practice law. That's committed to us by the Constitution of Florida. Wouldn't you agree?
I agree, Your Honor. We rely on it because that's the second, and I don't want to leave this first point. Let's ask ourselves, is 1621 an exercise of federal authority that is permitted under our principles of federalism? May the federal government say to this court, you may not admit someone to the practice of law? I have severe doubts about that.
But that's an exercise of their authority with respect to immigration, and I think you would have to admit that there's a textual commitment to the Congress of responsibility with respect to the control of immigration.
Your Honor, but not to the extent of having Congress direct this court to enforce federal policy. We think the principles been laid down in a number of cases.
Your position is that Title VIII, Section 1621 is unconstitutional.
Our first position is it doesn't apply because this court is not an agency. Our second position is that we have severe doubts about its constitutionality. And then finally, we want to point out that if it did apply to this applicant now has a route by virtue of the 15th June Statement of Federal Policy, has a route to get a full work permit.
Isn't the federal policy, the last thing you mentioned, a deferment of type not a change in the actual status of this applicant?
You're absolutely correct, Your Honor. If I said status, I apologize for that. It is a deferred action.
So the status of this applicant, who it seems to me may be a poster example of why perhaps federal law should be changed, but nevertheless, the status of this applicant is still illegal.
Your Honor, I would not use the word illegal. I mean, and I don't mean to parry with the court, but he entered this country legally. He's not subject to any criminal charges. He does not have documentation. But look at that policy of June 15th. If he now files an application, which he has been acknowledged, and he succeeds under that policy of getting a number, including ultimately a Social Security number and a work permit, what are we talking about status?
Well, Mr. Dallenberg, we're about a month before an election, and another person the person that's opposing the current president becomes president, hasn't he said he's going to announce that policy? In other words, my problem with it is we're in a state of flux, and what I think we're being asked to decide is whether at this juncture an undocumented alien who is in all respects would be a model lawyer should be licensed to practice law. Justice Kennedy gives you the federal reason why we may be powerless to do that. But I have my own concerns about what the license to practice law means in the state of Florida when we, the court, are licensing somebody. We are not saying, well, they're only licensed for pro bono, or they're only licensed for, advise foreign corporations. We give the license as a plenary license, and yet we will be representing to the state of Florida citizens that this gentleman, as wonderful as he might be, has full authority to practice law in the courts of this state. That's my concern about it. May be symbolic to some, but it has real implications for our requirement that we protect the public and who we license to practice law.
Your Honor, if you give this applicant a law license, he can practice law in Florida. The thing he cannot do is he cannot accept employment for practice of law.
How does that, what kind of other rules do we have to have? Do we have to, are we getting to the point that we're going to have to issue rings or bracelets or something so that someone who would hire him would be aware that they may be violating Florida law or federal law, not Florida law, by the employment process? Or, we don't require people to carry documentation of what I can or can't do as a lawyer. We have conditional admittees, and the public's not even aware that they've been conditionally admitted because it's not illegal for them to be practicing. But seems to me is that if you would hire someone who's not authorized and under the federal program, it seems to me is that you are in violation of federal law if you hire that person and pay them money. Are you not? Is that?
No, Your Honor. Let me see if I can answer several of these questions with this statement. All this court can do in terms of this applicant is to give him the credentials which he's earned. That's all you can do. You can't change federal law. I'm not. Indeed, if you admit Mr. Gutierrez to practice of law, he can only do what federal law permits him to do. He can take on pro bono cases. He could have other employment take on pro bono cases. We have lawyers in Florida doing that. Unless federal law permits it, he could not take.
How would we police him doing anything other than that? That's the real problem, as I see it. We don't give him a license that says you can only practice pro bono. So how in the world would we ever know if he is doing something other than practicing pro bono?
Your Honor, you have the same process you'll have for anybody who's admitted. If somebody breaks the law after they've got a law license, they're subject to discipline.
Well, maybe the
Here's
answer
a person
is
who's never broken the law.
Let me ask you this. You mentioned earlier that he is now, pursuant to the new executive order that has decided not to prosecute people in his case, he now is able to get a Social Security number.
Yes, sir.
He's now able to get a work permit.
Yes, sir.
Is that correct? How does that assist him in eventually getting a legal status in this country? You mentioned earlier that, but for that, he would have to leave the country for 10 years and then come back and apply for residency. Does that help him in the path to getting...
Until federal law is fully changed, there's still that possibility. And there'll be that possibility. But there are always possibilities when you admit people. And when you admit people, you expect them to follow the law. There's no reason to suggest that this applicant, who is...
Oh, wait, no.
But why would he be permitted to get a Social Security number if he's not allowed to work? I mean, I don't understand. See, that's where I'm having problems.
Well, Your Honor, if he gets a Social Security number, he will be permitted to work. That's my point about the policy announced on June 15th.
Maybe I'm confused. You mentioned earlier that because of this new executive decision to not prosecute people in his place,
yes,
that he is now in the path to being able to get a Social Security number? He's able to do that now?
Exactly, Your Honor, and I'm sorry I didn't make that clear.
But if he's able to get a Social Security number, then he's able to work.
Exactly, Your Honor, exactly.
Well, should we just defer to see this, let this process work through, rather than doing it before?
Your Honor, that's clearly a possibility. What we would respectfully submit is that the better course of action would be to say there's a segment of this question that rests with the federal government, and the federal government can act in that area. And there's a segment of this question which rests with this court. Article 5, Section 15 says that this court has exclusive jurisdiction over the admission.
Yeah, but not contrary to federal law. I mean, I think that if we start going down that path, then we're really in for some real problems with this court attempting to override policy determinations and laws enacted by this government, unless we're prepared to hold that these are unconstitutional.
Justice Lewis, I promise you, we're not asking this court to act contrary to federal law. We're just asking this court to act pursuant to its own authority to admit somebody who's clearly qualified.
But you said, I mean, part of your argument here is calling into question the constitutionality of a federal law. So you basically want us to, at least one line of analysis you go down, you want us to determine that the federal law is unconstitutional and therefore we can act in defiance of it. Or without regard to it, because it's void as unconstitutional. Isn't that your position? I thought that's what you
said.
said.
We do not ask you to rule on the federal law. You don't have to rule on the federal law.
But we have to obey it. Unless it's unconstitutional, we have to obey it, don't we?
Your Honor, if you decide that it applies, we've submitted it doesn't apply. We've submitted that we have doubts about its constitutionality. But all this court
I have not yet heard an explanation of how we're not operating under appropriated funds. I have not seen that argued.
Your Honor, I'm not making that argument.
If we're operating under appropriated funds and we're going to issue the license to practice law, I don't see how you get out of the force of that statute unless, as you did, you take the position that's unconstitutional. That seems like to be a predicate for us to accept your position on that part of the analysis.
Your Honor, I think there's another step here that you should look at, and that is it's a state agency.
That's an alternative. You've got, if I understand the statute correctly, there are two different things we're talking about. We're talking about action by a state agency, and we're talking about action pursuant to appropriated funds. Now, you've got your argument on state agency and whether we're that, maybe that's more arguable. I don't understand the argument about appropriated funds.
Your Honor, perhaps I'm misreading the statute, but I thought it was a state agency acting with appropriated funds. In any event, on the state agency issue, look at the brief of the Department of Justice.
Well, that's certainly not what the Department of Justice thinks.
The Department of Justice says that courts are not state agencies.
Well, but if I remember correctly, they say, well, even if they are, they're still the California Supreme Court. At least it's operating under appropriated funds and would be caught by that part of the statute.
Well,
what am I missing?
Your Honor, I think first of all, the question about whether it's within the power of Congress to dictate to this court
we'll get
what
back
it can
to
do.
the question of the constitutionality.
Well, that is a constitutional question. But, Your Honor, do we even need to reach this? We now have got a federal policy which gives this applicant a path to get a work permit, to get a Social Security number. What more do we need?
If he got a Social Security number, if he's able to obtain a Social Security number, then what is the issue here?
Your Honor, you've just summed up my argument.
Well, I mean, it seems to me, because I heard it in the conversation here today, you said he has to be a U.S. citizen. One does not have to be a United States citizen to be a member of the Florida Bar. Does one?
That's correct.
So, I mean, someone working for Greenberg Traurig in Buenos Aires who never plans to step in the United States can become a member of the Florida Bar if he meets all the other requirements.
Qualifications, yes, sir.
Okay, so don't have to be a citizen. And if he's afforded a Social Security card, which means he can work, then what's the issue?
Your Honor, I've been so inarticulate. I've not been able to make that point with the court.
Your point then, once he gets a Social Security number, then there's no obstacle to him getting a license to practice law in the state.
That's correct, Your Honor.
And whether he gets a Social Security number or not, that's a federal question. It's a federal issue.
And the federal policy now allows him a path to that very objective.
Well, how long would it take him to get this Social Security number?
I'm sorry, Your Honor?
How long would this process take?
You know, Honor, I wish I could answer that question. The people who filed on the first day of when applications were being received are already beginning to receive their approval, so we anticipate it will be quite soon.
So if we decided conditionally, based upon him satisfying that federal requirement, shouldn't be a problem unless there was otherwise a character or fitness issue.
Your Honor, I think that's correct. We don't even want to wait that long. We think here's somebody who's complied with every existing rule and should be given his license. But the point you make and the point that Justice Labarga make are quite sound.
Well, I'm concerned because I'm not aware of a category under the Florida Bar for the foreign attorneys to have full access to practice in Florida. I mean, we have a special provision and special section for foreign counsel to consult on foreign matters.
Yes,
but that's not what we're talking about today.
No, but Your Honor, where a person is legally in this country and not yet a citizen, goes to an ABA-accredited law school, demonstrates good character and fitness, takes and passes the bar exam,
who are entitled to be here.
That person would be admitted. And in practical terms, that's exactly where Mr. Godini
well, I mean, I thought that's the issue, that he's not in that same category, that those who are in a status that can be here, there's not an impediment. But if you do not have that status, you fall within the other category.
But Your Honor, where he can now work and
well, we're not there yet, though. As I understand it, is that there's a process that's available. Is that guaranteed? Is that what you're saying? Is it automatic?
No.
Well, again, that comes back to have you ever seen a court make a ruling on what may happen down the road?
Your Honor, in terms of admission, by the way the court is asking questions, you do that every time you admit somebody the bar. Not everybody who's admitted to the bar complies with all the rules or stays a member of the bar. In this instance, you've got somebody who has admitted qualifications. He's demonstrated his competence. He's demonstrated that his character and fitness.
He's gone through all the character and fitness requirements and passed the character and fitness?
You know, I don't want to overstate this, but I think my brother would allow me to represent the court that there are no pending questions of character and fitness.
Well, it just seems to me that although you're here on advisory opinion or the Board of Bar Examiners, we're talking about one person over a 4-year period, now in a unique position because of a change of the policy in June that may or may not continue after November. And it just strikes me that the better thing here would be to, first of all, either get the Department of Justice to provide the court with information, or let this go through with this particular person going and completing his character and fitness and then having it reported back, because we're only dealing right now with one person. Somebody's trying to make it literally a federal case, but we're talking about one person right now out of thousands every year. Correct? That seek admission.
Make sure that I understand your question. There's no pending character and fitness issue.
He's passed it.
The board has finished that examination, and a document authored
but
by the board.
But I thought this issue was a part of the character and fitness. I thought the issue of him being here illegally was a part of their character and fitness analysis.
Your Honor, I'm quite confident it was, but the board has announced that it has no more character and fitness questions relating.
Except for this one.
Well,
one question.
But that's not a character and fitness question, Your Honor. It is a question of whether you want to draw a bright line saying that someone who entered this country when they're 9 years old, when they were a child, they entered legally, stayed with their family after the visa expired, again, at an age when they had no idea particularly what a visa was, are that person going to be barred from admission to the Florida bar? And we respectfully submit that the answer to that question should be there should be no barrier.
Thank you.
Thank you, Your Honor.
Mr. Blythe, I have two questions. First of all, has he passed the character and fitness requirements other than this one that some of us think are big, others think not, whatever, that is pending before us?
Yes, ma'am. The board has reviewed the applicant's file, the issues that were raised in the character and fitness background check. The board determined the ones that they considered were not disqualifying for admission, but for this question that has been presented to the court.
Has the board, I'm looking at Authorized Legal Aid Practitioners Rule, Chapter 13, Emeritus Attorneys Pro Bono Program. Has the board considered that perhaps, I mean, again, I don't know if we're talking about a class of one, that if we're really talking about somebody that might be able to stay in this country but not be able to earn a living but can provide services pro bono, that there should be some amendment to one of the rules that doesn't provide for full membership in the Florida bar but allows them to do restricted work until the federal government makes a decision. Then at that point, we're really not granting him the ability to fully practice law. Has that been thought about? Because I'm looking at what we do with legal aid practitioners and emeritus attorneys, and we don't give them full licenses to practice law because they're obviously the students aren't yet members, but for those attorneys who are retired. So has that been thought of?
No, the board has not considered that, but that certainly might be a possibility. I mean, one of the things that I've heard mentioned in the context of the plenary license that is granted to practice law is that this court doesn't license lawyers to be co-pilots. I mean, when you give a license, you are saying there is no limitation on what that individual can do with that license within obviously the parameters of the license. You don't issue a license just to do litigation or just to do transaction or just to do pro bono or any of those sorts of things. And that's where I get back to the point that while I understand my colleague focusing on this particular applicant and the facts of his particular case, what the board has come to this court for is an advisory opinion. The board has not adopted a policy that undocumented immigrants cannot be admitted to the bar. What we are asking the court is that a rule that you want to put in place? Perhaps if your answer to that is yes, it may be appropriate at that point for the court to instruct the board to file a petition to change the rules so that we go through the rule-making process to bring that about. But while we have focused a lot on this particular individual, I just want to stress that from the board's perspective, this case is about that bright line rule and not just
And just to make sure, because I thought there's no question that someone who's a lawful resident of this state can receive a law license.
Yes,
is that
ma'am.
correct? So we're really only talking about somebody that is not, whether we call it illegal, unlawful, that is not lawfully a resident of the state or this country.
Correct.
Let me ask you, in this particular instance, is there any problem with his, with how long his bar scores will be valid? I can't remember what year he actually passed the bar.
My recollection is he passed the general bar examination in July of 2011. I don't recall when he passed the MPRE, but the bar exam scores are good for 5 years, so it's at least until July of 2016, and depending on when he passed the MPRE, it might actually be a little bit longer.
Can he ask for an extension?
He can petition the board and this court for an extension, and people certainly have done that. Yes, sir.
Thank you for your arguments.
Thank you.
Next case for the day is DMT versus TMH.
Another little easy case. Which one is it?
You may proceed.
Thank you. Good morning. May it please the court. I'm Michael B. Jones. I represent the appellant here today, DMT. This case started in the trial courts of Brevard County when the appellee before the court here today as the petitioner in the state court action.
Keep your voice up, please.
I'm sorry, ma'am. Is that better?
Yeah.
This action began in the state courts of Brevard County, Florida, when the appellee in this particular case, as the petitioner, sought parental rights over a child. The parties to this case were previously in a same-sex relationship. The way that this particular child was created is probably the crux of the case here today.
Are the facts? They say the facts are not in dispute. The Fifth District case, and they talk about the fact that they used funds from their joint bank account, paid them. They had essentially decided as a couple they were going to raise this child. And all of those facts, are those in dispute, or do you agree they're undisputed?
Your Honor, for the purposes of this particular case and this particular action, they're not disputed because at the trial level, my client filed a motion for summary judgment, and as a motion for summary judgment, she took all facts as being true. Had there been an evidentiary hearing on some of the facts, they might have been disputed. But for the purposes of this particular case, the facts are not disputed, and the facts under the case law and under the statute and under any reasonable interpretation of this situation, even with all of these facts, even with this act of conduct, course of conduct, even if completely true, would not be sufficient to give appellee parental rights.
If today, because there's the statute that says same-sex couple can't adopt, was declared unconstitutional, today, is there a legal way for a woman who is now giving, I guess in this case she's the genetic mother, to be able to legally have parental rights to this child under the law of the state of Florida, either contractually or through adoption or through the statute that was declared unconstitutional by the Fifth District?
Let me make sure I understand your question. Are you asking me if the statute that said that same-sex adoption was illegal was declared unconstitutional?
It was.
Right.
So what I'm asking you is there, if this occurred today, where two individuals who wanted to raise a child together agreed to how they were going to raise the child to give them, could they, you're asserting back then there was no legal way for this to occur. What I'm asking you is today, in 2012, is there a legal way for this to occur? Under the 3rd District Court case, yes. It would require the consent of both persons to do an adoption, and they would both jointly adopt. But that couldn't have occurred back in 2006 because the statute was in effect and had not been declared unconstitutional. That's absolutely correct, and it would not be a retroactive application of the statute. And today, your client is not willing to, as I understand it, is not willing to even give the genetic mother access to be part of this child's life. I mean, that's the status, that she wants nothing to have their child to have anything to do with the child. That's absolutely correct.
Could we also just understand that if we're saying we have stipulated or understood facts, is there or is there not a written document through which the individual who had submitted the genetic material gave up all, I'm not sure I'm saying it correctly, but essentially gave up all claims, rights, that kind of thing? Is there not? Because I think we're having trouble finding that document, or is it in the record, or what's the status of that fact?
That fact is absolutely true, and it is stipulated to. In the petition, in the amended petition that the appellee filed in the trial court below, she admitted that she signed a document which waived her parental rights to this particular child. It was not contingent on Section 742.14 being declared constitutional or unconstitutional. It was an absolute waiver, and that's part of the stipulated facts.
And that's not challenged. That is a given for what we're looking at.
That was their own admission in their own
but they
amended
challenged
petition.
The legal implications of that. I mean, basically, isn't their position that was just some paperwork that was signed and it really didn't fit it did not fit the circumstances of their particular case?
Well, it absolutely fit the circumstances of their particular
I understand that your position, but I'm asking that their position is it didn't fit the circumstances of their case, right?
Well, I think they're trying to argue after the fact, we really didn't mean this. So, yes, they are taking the position.
So that's a disputed fact then.
Well,
that's a critical. I mean, if this, it seems to me, and correct me if I'm wrong,
mm-hmm.
I mean, if one is to determine that this is a given, that there's a release, that it's valid, that resolves and removes all other issues, wouldn't it?
Oh, it absolutely does.
So that's maybe a factual question that we can't even reach then if it's disputed.
Well, I think you can reach it because I don't think they've denied that the release said it, and I don't think they've denied that they signed the release, but they're making the argument that's often made just in simple contract law.
That's a matter of law. That's not valid.
That it's a matter of law. You can't go behind it. You can't bring in parole evidence. You can't look to intent. The clear language.
Wouldn't the actions of the parties here? It seems to me that what we have here is one person donating the egg that was fertilized mm-hmm. and placed into the other one. Correct.
Correct.
And that the intent was that these two people were going to raise this child, despite the fact that we have this pre-printed form that basically says you're giving up. So do we get an opportunity here, or should we even take into consideration the actions of the parties and what they intended at the time that the child was born?
No, Your Honor, I respectfully submit that you should not. And the case law and the long history of the case law and back into the common law goes back into the fact that
Except we didn't have this kind of same-sex situation.
Well, I understand that, and that brings to another point, and I'll address you first, but under the common law, of course, there wasn't artificial insemination, there wasn't in vitro fertilization, but you had a situation now that when you do those things that are not in the common law, they are legislative actions and determined by the legislature, and the courts traditionally have given deference to the legislature in doing that policy. But going back to your question about the course of conduct, the long history and history of the case law of the state of Florida has been that parties that may be together with a child under many different circumstances, a step-parent, a grandparent, under many different kinds of circumstances may have a relationship with the child, but when the actual parent decides that that relationship is no longer appropriate for the child, then that is terminated.
Isn't the different? Oh, go ahead.
But I guess when I look at the statute, and I think part of the Fifth District's analysis here is that this printed document, not the statute, but the printed document basically says, I'm giving up my rights to this child, but it says, I understand that the recipient of the eggs, her partner, their successors, et cetera, et cetera. And so you're saying that the biological mother doesn't fit under her partner portion of this statute.
Well, first of all, I'm going to be very careful with the term of biological mother, because there is biology in implanting the fetus into the womb and biology into the
donor
birth.
Of the egg.
If we're talking about the genetic person, yes, ma'am, yes. They do not have a right. Just like a grandparent donates 1/4 of the genetic material, and if a parent who has the constitutional rights under the Richardson case that was decided by this court determines that there should be no contact with the grandparent, there is no grandparent rights.
I'm glad you brought that back up, because
yes, ma'am.
I'm very familiar with the grandparent cases.
Yes,
There's
ma'am.
a mother and a father, a legal mother, a legal father. I'd like you to address the implications of the Lear, L-E-H-R case out of the United States Supreme Court. What I'm finding, and I want to understand it, is that a sperm donor, if it was a one-night stand, and they're a real person, but they're essentially a sperm donor, and the child is born of that father and then that mother, that person under the United States precedent, if they participate actively in raising the child, has some constitutional rights. But you're saying that as I understand this, that this woman who participated by donating her egg and then agreeing with her partner that this child would have two parents to raise the child, that there are no constitutional rights involved whatsoever, and that whether it's under strict scrutiny or a rational basis. And is that correct? That is, that somebody who donated the sperm would have more rights than somebody that donated the egg?
No, ma'am. If I may break that down, you asked two questions, I think. The case in Lear involved an impregnation in the way that was customarily done through sexual intercourse. When you have a situation where you donate genetic material, you're into the Lamatada case. I'm sorry, I apologize. In which it was a situation where a male donated the sperm, but not in a traditional manner of impregnation, and in fact had a relationship with the child for a period of time, and the birth mother said no further. In fact, they had an agreement to have some contact, and this was the same thing in the Wakeman case, and I admit Wakeman is factually distinguishable, that the donated material is not relevant, but the issue is relevant.
Whether somebody has sex or not? Is that what we're saying?
Well, that's what our case law has been saying.
Well, but here is the problem, and I think the constitutional problem that at least the Fifth District struggled with, is that clearly, and the best interest of the child analysis doesn't come in unless there is constitutional rights involved. The statute that we're talking about, did it contemplate? It contemplated in most situations where an egg was donated or sperm was donated, it would be from somebody completely foreign to the couple. And it would be a heterosexual couple having either sperm donated or eggs, and it would be not in the best interest of the child, or at least from my point of view. I would think from most people's point of view, for somebody who was just basically foreign to that relationship to be able to assert rights. And it seems that that's what that statute that was intended to do. Would you agree that that's the norm, that somebody donates sperm or eggs and therefore knows they're giving up any rights to be part of that child's life? There's a couple involved, and it is in vitro fertilization.
I think that would be the normal situation.
I mean, in fact,
and again,
in many cases, it's actually, I mean, it's implanted. I don't know if the sperm, it's just foreign even to the person until it's implanted. So did the legislature contemplate that they wanted to exclude a situation like this, or was it just not intended?
I think they intended to include it, and I don't have legislative history where somebody stood up and said, I would specifically do that. But I think when you look at the entire sweep of the legislation that's in the state of Florida under these particular situations, the clear statute, which I understand there is the third district court case that's ruled it unconstitutional, that there should be no same-sex adoption, the constitutional provision of no same-sex marriage, the very specific definition of what could be a commissioning couple using a male term and a female term. I think the clear implication of the totality of the Florida legislature was that they absolutely did not intend any of this to apply in any way to a same-sex couple. I think the surrogacy type of situation was the same way that they could, where two men together could donate sperm and get a third-party egg and implant it in a surrogate. I think that was clearly not permitted under this statute, and I think when you look at the clear case law...
When you say it was permitted,
it
would not give the person legal rights.
That's correct. That's correct. Yes.
How long has this statute been in effect? 742.14.
I don't know.
When you look at just the plain language of the statute, the statute says a commissioning couple,
right? And
a couple is two, and these two women were the commissioning this. So it just seems to me the literal language of the statute does not cover this situation.
I tend to agree.
Under the literal language, these two women would be a commissioning couple and would be excluded from this.
I must respectfully disagree, because the clear language says a commissioning couple is defined as a male and a female, a mother and a father. So I think that two women or two men would be, by the clear language of the statute, excluded.
You're in your rebuttal.
Thank you very much.
Your Honors, good morning. May it please the Court, my name is Robert Siegel. Christopher Carlisle and I are here on behalf of Blle. It is our position that Chapter 742.14 does not apply in this situation.
But why doesn't that release just trump everything?
There are a lot of problems with the release. If you look at the Lamar-Atata case that was cited earlier, there the parties had a very clear contract wherein they expressed their intent that should the woman become pregnant and bear a child, that the father was not going to have any rights, that the mother was not going to seek an adjudication of paternity. In this case, we don't have a contract. We have an informed consent form. The form was signed essentially to benefit the doctor and to make sure that Blle knew what she was getting into when she went forward with the procedure.
Well, is that a question of law or a question of fact? And again, and this goes back to some questions that Justice Lewis asked your opponent. That concerns me. We're here again because it was on summary judgment, and the summary judgment appears to say that they had a verbal contract to exactly do what you're saying, but then you've got something in writing that appears to be contrary. And yet, so even if we agree with some part of this, doesn't this need to go back for a factual hearing?
I believe that there was sufficient facts before the court and sufficient facts before the 5th District where there could be very basic facts distilled from that would say, look, if we find these facts to be true, then we can go forward and make a decision as a matter of law that Blle is entitled to rights, regardless of making further factual findings concerning some of the details in the informed consent
What the
form.
5th ECA is, as I understand it, their real question to us is whether or not there is a constitutional right under federal and state law for there to be two birth moms. Isn't that really what they're asking us?
I think the question really is does appellee have constitutional rights to parent this child that she helped bring into the world at a point in which the parties both had an intent to parent this child? And the question, the answer is that yes.
And they're not asking us to treat one who gave birth as someone different other than a birth mother, correct?
Correct.
So they want us to treat, under the law of Florida, there to be two birth moms.
They're not necessarily
constitutionally.
Two parents, both of whom are women. We're not seeking a classification that one is a birth mother, one is not a birth mother. There's no effort at this point to exclude the birth mother, DMT, from the life of this child. We're seeking merely an adjudication that TMH appellee has parental rights to this child that now exists.
Don't you think the statute, by its plain language, clearly applies here?
No. It appears, if you consider the statutory scheme, and it seems to be from 742.11 down to 17, in 742.14 it talks about a donor other than the commissioning couple. And rather than using a commissioning couple, they've used the commissioning couple, suggesting that what was contemplated at the time was that this statute was going to be used by men and women who were not able to conceive a child, and we're going to use assisted reproductive technology in order to do so. There doesn't seem to be anything in this statute that in any way suggests that they intended to include people of a same sex, that they intended to disallow them.
What year was the statute passed into law?
1993.
At that time, though, in looking at the policy of the legislature in the state of Florida, they had a law that said that same-sex couples couldn't adopt. So what would make us think that the legislature at that time wasn't clearly intending that this would apply to a situation where you have a same-sex couple? Whether that's constitutional or not is a different question. But you're saying now that the legislature never intended for this to apply in this situation. I find that to be, if you think back to 1993, absolutely contrary to what the legislature intended in every other aspect of this type of situation.
Well, in an adoption, parties are seeking the permission of the court to take custody of a child who is a ward of the state, who is essentially in the custody of the state.
Well, that's not true, because in 1990, when she gave birth, when the birth mother gave birth, if your client had sought, because that's one way to do it, to also adopt the child with the consent of the birth mother, that would not have been lawful in the state of Florida.
But engaging in
Can you answer that, yes or no? Would that have been lawful?
No.
All right. It now would be lawful.
Yes.
There would be a path to do this if two women wanted to raise a child together and have stable parental relationships. For the person who was not the birth mother, who was either genetically supplying the egg or they both wanted to have two individuals, loving individuals, be part of their life, they could seek to adopt. But that wasn't the law at the time that this occurred.
In 1993, these parties were legally entitled to use assisted reproductive technology in order to produce this child. What they did was legal. What they did was ethical. There was no expression by the legislature, no specific expression by the legislature at that time that said that they could not do this. And so it's not as though they're seeking a state-sanctioned approval for an adoption, which is what a number of these cases, particularly the case cited out of New York says, and particularly in XXG, it was brought up in that context as well, is that that's an administrative procedure where you're seeking the approval of the court to determine whether or not a parent can have rights to a child. And Chapter 63 has consistently changed, but there are provisions in there for taking rights away from a parent, for giving rights to people that aren't parents. But this is not that. This is two people that got together and engaged in an entirely legal and, again, ethical procedure to bring about a child that they intended to raise together. And there's nothing expressed in the law to suggest that they should not be able to do that.
Okay, so now you're saying the law doesn't apply. Your opponent says the law clearly applies. The Fifth District seemed to say, well, the law applies, but it's unconstitutional is applied here. So which way, what's the path that you want us to go down, that the law it doesn't even apply, therefore there was no reason to declare the law unconstitutional, or that the law as applied to your client is unconstitutional?
I'd suggest that the court can make a ruling in this case without having to find the statute unconstitutional, that would be a preferred path. But if the court is unable
and
to...
And how would we get there to say it doesn't, the plain language of the statute doesn't apply, even though they name a commissioning couple as being a man and a woman?
Right.
So where is it that wouldn't, where would your client fit in or not fit into the statute?
She is not a donor who would have waived her rights to parent the child or to the genetic material under 742.14. She simply is not a donor in that sense.
How do you get around common understanding of the term donor in this context? A donor is someone who provides biological material for a medical procedure of some sort.
Respectfully, I don't believe that is a correct understanding of the term donor. I don't think that the statute was intended to exclude everybody that provided genetic material. It was intended to exclude people that didn't intend to participate in the life of the child.
But it has the particular people that aren't covered, and it expresses that. But you're saying that she's not a donor, and I don't understand how you can fit that in to the common understanding of this term of art. It really is a term of art. But they talk about a donor in the context of these sorts of procedures, and the understanding of that is pretty well established, isn't it?
I'd say that it's not. If you look at the KM case that was cited in the brief from California, there they indicated that it was very clear that the parties did not intend to relinquish any particular rights, and that they intended to raise the child together. That's the exact same situation that we have here. There was no intent expressed by either of these parties until this litigation started that they didn't intend to raise these children together. Or the child together.
Let me ask you about your understanding about the district court's opinion, because I read it and I was kind of like with Justice Periani, I'm not sure exactly which route they were going, and maybe they're going both routes. What is your understanding of what the actual holding of the Fifth District is?
I think the Fifth District, it was a two-part holding. They found that the statute doesn't apply, and that if it was applied to this situation, it would violate both the privacy provisions of the Florida Constitution and the equal protection provisions of the United States and Florida Constitutions.
Would you address the purported release? I don't know how you want to describe it, or the concept of a release in this case.
We're talking about the informed consent form that was signed.
Well, that's what I'm trying to figure out exactly what we're talking about.
It was an informed consent form. It was a 8 or 9 page document where the procedure was described, what they were going to do, how they were going to do it, the risks that were involved in the procedure. There is a paragraph on the very first page of the form where it indicates that appellee does, in fact, waive her rights to the genetic material and any offspring therefrom. But I would suggest to the court that since it's an informed consent form, and it's not a contract as we saw in the Lamaritata case, it's an informed consent form. First of all, you don't have any mutual expression by the parties that they intended for that waiver to exist. In fact, appellant's name doesn't appear on that form in any place. The only place...
The question is, does the signature, though?
I'm sorry?
Does the signature appear on the page?
Appellant's signature?
Yes.
No.
Okay.
No, she's not mentioned in the document.
And the question being, so this is a unilateral form, it's not a contractual thing. But I mean, in Florida, even informed consent forms on cases such as Flowers out of the 3rd District, which was a sterilization procedure, is that they have been interpreted to operate as full release kinds of documents, not just as information for informational purposes.
Well, I would suggest to the court that there's nothing in that document that suggests that it rises to the level of a waiver of such a significant right on the part of appellant.
Okay, why? I understand just what you said, but why?
Because there's no mutual expression of intent between the parties. The actions of the parties, both before the signing of that form and after
if you settle a lawsuit, do you have the party who is executing the release, both parties sign the release? Or do you just have the party who is doing the releasing sign it?
A lot of times it's simply the party who's doing the releasing signs.
That's
the
typical
release.
how we do that in the law.
But it is not consistent with the actions of the parties. And
I understand that. I understand that.
The form itself is internally inconsistent. Justice Quince mentioned one of the inconsistencies. There are several throughout. There's indications that the child is intended to be raised by the husband and wife in this case. There's no husband and wife in this case. That they're going to be obtaining the sperm from the husband. Again, there is no husband. There's even a provision that says that the appellant and her partner are waiving various liability provisions as to my client. Appellee is the partner.
Do those under Florida law, provisions that may not apply or may be inconsistent, does Florida law hold that that would negate a valid provision in the release, a release?
I think it would create enough inconsistency for the court to then entertain testimony concerning the intent of the parties. And if the court
the case, if that's what needs to be done, then we are not ripe for a decision on summary judgment then.
Well, again, I think that there were sufficient facts in the record.
If we hold, what you just said is that you think there are sufficient facts. The other side says, no, this is a matter of law. So then we're not even ripe for a decision, though, because we have to determine or have somebody determine factually whether this was the intent and the operation of factually of this printed document with the signature.
Well, maybe this is where the confusion with the holding of the 5th District comes in. As part of the constitutional analysis in establishing what is the parental right of appellee, it was suggested that in the case of a man, an unmarried father who's seeking an adjudication of parental rights for a father, he would need to show, in order for his inchoate right to parent to convert into one of a constitutional significance, he'd have to show a biological connection, and he'd have to show that he made a substantial effort and commitment to become a parent to this child. Once he had done so, he then has a protectable interest under both the state and the Florida constitutions. And so in this instance, since appellee donated biological material, and since she very clearly demonstrated a commitment to become a parent to this child, there shouldn't be any question at that point whether she does or doesn't have a right to parent the child. She does. And that should be the end of the inquiry at that point.
I understand that. Could we go back to what I'd asked before? You answered a different question, and I understand that you would like to answer it in that way.
Right.
But again, we have to get across that threshold question. Is there an issue of fact with regard to the impact of this writing, whatever it is? Because each party is asserting that a different factual posture.
I understand. I guess I was hoping to answer the question by analogy that the trial court and the 5th District, having made those simple findings of the biological connection and the commitment to parenthood, that's all that would be necessary for a court to find in order to get past the summary judgment issues and make a finding as a matter of law.
Well, you'd have to make a finding that the release is invalid. There'd have to be someplace along the line, or that this is not a release. Whatever this writing is, it's not a release. I mean, somebody has to make that determination. Right. I mean, up to that point, it just seems to me it's a legal argument, and I understand you may have the prevailing argument, but we are not to that point until that issue is resolved, and that involves, it seems to me, testimony, facts that would have to be addressed, and you may prevail on that. I don't know, but we can't determine the facts.
What was presented at the summary judgment argument not only was this informed consent form, but was also the affidavit of the doctor that performed the procedure. And the matters that were alleged in that affidavit, taking all of those into consideration, the court could have found that there wasn't any question at that point, and this is what the parties intended, and therefore...
What part of that affidavit?
I'm sorry?
Which parts of that affidavit?
The part of the affidavit...
what the doctor would say, how would that affect the intent of parties, and with the doctor not being one of those parties?
Well, the doctor said that he understood that both parties had come to him with the intent of creating a family that they were going to nurture together. that they had come in, that they had waived any sort of medical privilege in conversing between each other about these matters.
Doctor was just trying to avoid a malpractice action.
The doctor's a good man. I don't believe that that's the case.
I have no doubt, and I'm not here to cast aspersions upon the medical profession. I'm
No,
trying
I'm
to determine.
Neither am I.
That,
But that's a consideration that perhaps a judge should make on live testimony as opposed to a cold affidavit.
How did the 5th District deal with the, the waiver? I mean, it's not a contract as just with the two people, two parties. So how did the 5th District deal with the medical release, if you want to call it that, as to her relinquishing her rights? Did they address it?
Yeah, they found that based upon the facts that were presented in the pleadings and the other summary judgment evidence, the affidavit of the doctor, the form itself, that she did not intend to relinquish any of her rights. So,
and my understanding, and maybe when your opponent gets back up, he can explain, that they're really not hanging their hat on the release. They're hanging their hat on that the statute, even if they did intend to raise this child together and both of them have parental rights, that the Florida statute prohibits that from happening under the law of the state of Florida. Isn't that the issue that we're here on?
That's the certified question.
But I maybe I need to look back at the briefs as to whether the first question would be that if there was an actual waiver between the two parties, that alone might be enough to say that your client could not have parental rights to this child.
Right.
So that's is that a threshold question that has been conceded for the purpose of this case in front of us, or is that being raised by anyone now, that the release itself is really the end of the question, not the statute?
It's been raised, I suppose, as an alternative theory.
Okay.
That you can take away her parental rights by finding that she waived her rights under the
But what you
form.
would say to that is, if we were to go down that path, you've got to consider that it's equivocal. It's not unambiguous. It was done for the protection of the doctor and usually for the couple. Because, again, in most cases, you've got foreign, I don't mean foreign by out of state, you've got, what's the word that's used? Foreign eggs and sperm that are being used for a couple to be able to conceive a child.
Right.
What is that called when they called something?
Just an anonymous donation?
Maybe anonymous. It could be, but that would be the norm.
Yeah, and that's something the doctor made clear in his affidavit, was that form was something that he typically uses for anonymous donors. And there are parts in that form where you can circle it to say that the donor is known or unknown. It's not circled in this case. There's no question that they're known to each other. But it was a very general form.
It seems a problem to me is that you have a client who had a form by operation of giving up the egg for fertilization, by the operation of the form itself with the doctor, gave up rights, had an operation of a statutory provision that, again, by Florida law, made her give up whatever parental rights that she may have had, but yet there's no written agreement or contract to the contrary that says these things do not apply in this circumstance. So it seems like it's more of you're asking this court to implement social policy that's not reflected in the Florida statutes, not in the Florida Constitution, or to me in the U.S. Constitution. But you're asking us to make a constitutional ruling on social policy.
We're asking the court to make a determination that appellee has protected parental rights based on the actions of the parties. They signed a form, but the form is patently inconsistent with their conduct. And the terms of the statute, again, would respectfully suggest that it really was intended for situations where married couples wanted to avoid the possibility of interference by an anonymous donor, and that statute does not apply to the facts of this case.
Thank you.
I'm blinking red. Thank you, Judge.
To answer the question, yes, I think the release in and of itself wins our case. But I don't. I think even if we didn't have the release, even if she had never signed a release, I think the facts of the case are favorable to us and win the case for us.
Let me ask you briefly: Do you have any problem with the way this question is certified?
I would not presume to tell the Fifth how to certify a question.
Well, but you can presume to tell us if you don't like it. I mean, I asked. I give you permission.
Thank you, sir. I think that the Fifth wanted to address the constitutional issue. I think the Fifth tried to deal with the fact there was a release. I don't think they did it effectively, and I think they wanted basically to ignore it.
Well, if we leaving aside the issue of the release, if we decide that the statute does apply, then we've got to confront the constitutional issue, right? I mean, it's been raised, or why is that not right?
I don't think you do, because I don't think there's ever been a protected class for genetic material.
Well, I understand you think they don't win, but that's a different. You're talking about a protected class. That's part of the constitutional law analysis.
Yes, sir.
So that's confronting that issue.
Yes, sir. Obviously,
but if you look at the Lear case, I mean, we've mentioned it in other contexts, and particularly in those where there's an attempt to cut off the rights of a father, and the question of notice to who gets notice with regard to that. And the U.S. Supreme Court in Lear's basically has said, that you have to give an opportunity. There's an opportunity to parent. You can't just say you're not going to. So, and it seems to say that if you exercise that opportunity, that you do come under then the protections of the United States Constitution on the right with regard to children, doesn't it?
It does, and in fact, it even goes back to the Stanley versus Illinois case. But those were all situations and where there is a distinguishing made between the biological creation of a child in the normal sexual intercourse way, and it does not contemplate a genetic donation.
But why is that? That the idea that we would, again, in 2012, whether it's 2006, say we're okay with unprotected sex, a one-night stand that can produce a child, but where two people get together and agree they want to raise a child together, and they actually start out and do it, that constitutional right is worthy of less status, or doesn't exist, but the one-night stand has greater constitutional status. Do you not? I mean, again, I understand that may have been the case 100 years ago, because our society was different as far as there. But is that not a situation that at least implicates equal protection rights of women over, at least to have equal status as men?
No, I don't think so, because I think you can deal with genetic material from both a woman and a man and say that it is not a protected class, not a compelling state interest, whatever level of scrutiny you want to put on it, and put the actual way of traditionally creating
if you have sex the good
old-fashioned
way where it's constitutional, but anything else doesn't give rise. I mean, and that could, and honestly, I don't. This is a raises lots of questions, constitutional and otherwise. So I'm asking this really to try to get guidance from you as far as why one has higher status than the other.
I think you're really talking about social policy issues.
Well, we may be, but sometimes social policy and constitutional policy come together.
Yes, ma'am, they certainly do, and that happened in Brown versus the Board of Education. There's any number of cases where that comes together, but
it came
those
together
were
in Lear versus in the United States Supreme Court case.
But that has been in the tradition of how paternity is determined, and the Florida paternity statute. The first thing you allege in your complaint for paternity, after you allege venue and jurisdiction, is that the parties had sexual intercourse in a particular venue, and that gives you the jurisdiction, and it gives you long-arm jurisdiction under the long-arm statute. So there very definitely is a legislative distinction made. And since we are talking about it, and your questions are very good and very academic, but I think
pandering won't get you anywhere.
Because he said good and academic, meaning it has no relevance to this case.
Well, I think they go to social policy, and I think social policy has always been a legislative priority.
So you think that the 5th District was involved with social policy, not constitutional?
I think so, Your Honor, and I think that they go down a slope that of the implications. I think that their decision undermines the pendings of Richardson. I go back to that. I'm certainly not lecturing this court on that decision. You made it, but there has been that determination that even though there's a genetic component in the Richardson grandparents, even though the Richardson grandparents were at one point actively involved in the children's lives, that they do not have any kind of right that comes from either genetics or comes from previous involvement with the child. And the situation opens up, and this is much more in the amici briefs than either of the major briefs.
If you would sum up.
Yes, I will. But basically, you're opening up this best interest of a child type of analysis to a step-parent of either gender, to a boyfriend or a girlfriend, to somebody that's richer. It just opens up a whole bunch of things that have been against the rulings of this court and the appellate level courts of the state of Florida. Thank you very much.
Thank you for your arguments. The court will be in recess for 10 minutes.
Please rise.
Supreme Court of Florida is again in session. Please be seated.
Our next case for the day is State Farm Mutual Automobile Insurance Company versus Curran. You may be proceeding.
Thank you, Your Honor. May it please the Court, Elizabeth Russo on behalf of the petitioner, State Farm Mutual Automobile Insurance Company. We're here, this is an uninsured motorist case in which the 5th District has raised some fairly broad issues about policy conditions that are set for insureds and what the consequences are for a breach. But there's two factors that we think are critical here that are also present in all of the cases we're asking you to follow that should be concentrated on. And one of them is that this case involves a willful breach, and the other one is that the type of condition that's involved is one that is designed to get information for the insurer that can only be provided by the insured.
Well, let's look at, you say we have to look at those. Shouldn't we also be required to look at uninsured motorist cases and coverage? Not fire coverages, not life insurance policies, but uninsured motorist coverage. And
the cases that I'm talking about that reach the result that we're asking the court to resolve, there are two of them are uninsured motorist cases that involve exactly those same things that I'm talking about.
Not from the Supreme Court, though.
I'm sorry?
Not from this court.
Not from this court.
Right. And isn't our beginning point on the discussion that uninsured motorist coverage is a creature of statute?
It is.
Unlike fire, unlike life, unlike all other types of coverage other than PIP. Right?
Yes, it is.
And the UM statute, as decided by this court going back to Mullis, and you've been doing this work you're familiar with these cases, Salas, 10 cases, say that the uninsured motorist statute is the reciprocal of financial responsibility laws.
Yes, Your Honor.
And it also says that you can't have exclusions, exceptions, and policy conditions that restrict or are more restrictive than what's required by the statute.
It doesn't. We can't have exclusions that are going to exclude the coverage that's intended by the statute. But we can certainly have. We don't have no policy at all. We can certainly have policy conditions.
And under the PIP coverage, insurance industry has full medical examination provisions in every instance, as built in the statute.
In PIP, I'm sorry, did you say in PIP, Your Honor? In
right.
PIP, they had the right to, yes.
Yeah, right. I mean, it was written in from day one. The UM statute doesn't even have a provision for insurance company medical examinations, does it?
It does not.
And the UM statute is designed, according to our case law, to operate not as first-party benefits, but on the same basis as third-party. It stands in the shoes of the tortfeasor.
Of the tortfeasor, but it is still first-party coverage.
Well, our
case
law says that
it is a contract.
It may be a contract, but it is interpreted as it would be if it's a third party.
It's a hybrid. It's true that the insurer stands in the shoes of the tortfeasor for purposes of whether there's liability and damages, but it's also a first party. The plaintiff has paid for the insurance.
Well, sure, I mean, that's what we say, but it's in the nature of, unlike other policies, other coverages, I should say, it's in the nature of a third party. Relationship stands in that posture, according to our case law.
Well, yes, well, once they get in litigation with each other, yes, that's true.
Well, once the accident happens, not just once litigation, it is that once an event occurs, or the event that causes an uninsured motorist claim to arise, then at that point you are you don't have to have litigation. You are adversarial in your posture.
No, respectfully, Your Honor, I don't agree with that because we have.
Maybe you should read some of our case law that says that.
Well, I understand it as when you're looking at the tortfeasor versus the plaintiff, but when you're talking about just the coverage, we've sold them uninsured motorist coverage, and this case is a very good example of the first thing we want to do is see. All right, I mean, it can't be that we get a call from our uninsured motorist insured saying, I was just in an accident and I have really bad injuries, so please send me a check for $100,000, and our obligation is to send a check for $100,000 or we're not in compliance with the statute.
Well, nobody suggested that.
Well, I'm saying there
But
are
you have no
certain
provision in the
steps that have to be
statute
gone
compel,
through.
but there is no provision in the statute to compel an insured by any company, it's not State Farm, any company, to send, for example, if you live in Lakeland or you live in Tallahassee, well, policy says you have to go down to Miami for an exam. There's nothing that authorizes
that says that. But here we have. Let's just take this situation, this particular situation, which is there's an accident in June of 2006. At the time, the plaintiff was pulling out in a red light. She was stopped at a red light, is pulling out, and the car behind her bumps into her. Goes to the emergency room, no problems are found, no broken bones, nothing. We don't hear anything more in terms of any claim being made against the uninsured motorist. I think she got PIP and something from the tortfeasor.
Well, you don't get PIP from the tortfeasor, you get PIP from his own carrier.
Okay, but PIP tends to be $10,000 and under.
There's
no indication to us, in other words, that there's any kind of serious injuries involved here.
Can I just stop you? It sounds like you're defending a bad faith case. And I thought we were here on the issue of whether, as a matter of law, by her not coming to a particular day set for a compulsory medical examination, she forfeits her uninsured motorist coverage. Isn't that what the case is? I mean, you may be right that the actions of the plaintiff justify the insurance company not immediately tendering their $100,000.
And I'm not faulting her for those actions. I'm just saying that it was an unusual diagnosis that she came up with a year later.
In other words, the issue here is whether by not jumping at the point that the insurance company said, come to a medical examination, she forfeits her $100,000 of uninsured motorist coverage. Is that not the issue here?
Well, you can phrase it that way, but the way that
the jumping might have been, it's her not complying with the initial request.
It wasn't just an initial request.
Whatever it is, with not coming at a particular time, because eventually there was a medical examination, correct?
But there was also a medical examination set up by consent before there was a suit filed, by consent, with the plaintiff.
Did she eventually have medical examination?
About over a year into the litigation.
Did you use the medical examination in defending this lawsuit?
This is the problem. This is the problem. What we needed to find out at the time that the claim was made, just like if you're getting the telephone call, hi, I have really bad injuries, we need to find out, okay, what are the injuries? Because there is the bad faith statute sitting out there, and there's attorney's fees the second that anything goes into litigation against an insurer.
Not on uninsured motorist coverage, it's not.
If there's any kind of question over the coverage, if there's any question over the coverage, yes.
Yes. When you file the case, it says specifically the provisions of 627-428 do not apply for actions brought pursuant to this section against uninsured motorist insurers, unless there's a dispute over coverage.
Over coverage, exactly. And
that's not the accident.
This is what she's raised. But so the first thing that we need to find out is, what are your injuries, so that we have at least the opportunity to determine.
But the thing is
is this one that we should pay?
Excuse me. She offered, the plaintiff in this case, offered to submit to the CME. Was it 7 days after the scheduled examination? So what changed in 7 days that you couldn't have found out? You're telling us that we need a CME right now so we know what his injuries are about. She said no. 7 days later, she said, okay, let's do it. And you said no.
No, that's not quite accurate. What happened was, we had worked out with her, after much back and forth with the correspondence, we had worked out with her a date and a time, which was September 12th. She agreed on the doctor. She agreed on the time. Everything was agreed upon. And then 2 days before that, she files a lawsuit and says, and cancel that examination. So to say that she was quite willing to go 3 days after or 7 days after, yes, she writes a letter, shortly after that and says, okay, well, now would you like to schedule the examination, but you still have to comply with all of our stipulations or we're not coming. And one of those was you only get one examination. We would have to agree to that. Whereas when it finally went to trial, they had multiple doctors in different disciplines, and we have no obligation under the rules of civil procedure or under our policy to get only one examination. And that's what she was insisting upon.
It still
and
seems
when we
to
tried
me
to
you're starting to talk about a very legitimate defense to the bad faith action. In other words, those actions, at least from my point of view, of the plaintiff, if you were being, quote, set up for bad faith, are absolutely appropriate to raise in the bad faith action. But I'm still struggling with this issue of how she forfeits her coverage of uninsured motorist coverage, and is it a question of whether you are prejudiced? And then if it's prejudice, then that seems to be the issue. Is it whose burden is it to prove prejudice? Is it your burden to prove prejudice or their burden to prove lack of prejudice? So to me, I see it more as a failure to cooperate, and then did it prejudice the insurance company, and therefore she forfeits her coverage. But the way I see State Farm's position is once she didn't come within the first 30 days or whatever, there is a complete defense. She has waived her uninsured motorist coverage.
It's not a question of when she didn't come within the first 30 days. It's a question of not coming before filing a lawsuit. That's the critical thing for us and for our policy.
So once she filed the lawsuit, did you immediately request that the lawsuit be abated so that you could get your mandatory compulsory medical examination?
The plaintiff did not immediately dismiss her action. It's not for us to.
I guess what I'm looking at is the Fifth District's opinion that it said although Curran prematurely filed suit, presumably because it would only result in State Farm never raised this argument, presumably because it would only result in the abatement of the claim instead of a complete defense. Had the State Farm raised this argument, the trial court could have ordered the action abated, necessitating compliance with the CME clause before either party was burdened with the expense of further litigation. Instead, State Farm maintained the breach excused further performance of the contract. Okay. So is that correct, what the Fifth District has said?
What happened is that she files the lawsuit in breach of the contract. Now, who do we look at immediately? Who has done the wrong thing? It's the plaintiff by filing the suit in breach of contract. Why doesn't she dismiss the action? Why is it looking to State Farm to, let's say we had moved to abate it. She would have taken the same position she'd taken in opposition to our summary judgment motion, which was, I don't think that I did, I don't think you should abate it. I think I did comply with the contract because all the conditions that I asked for were reasonable, so you should just deem me to have complied. And with that trial judge that we had, he would presumably have done the same thing he did with summary judgment, which is to say, no, I'm not going to abate it. I think that she really complied well enough, and you guys just couldn't agree on the conditions. Well, so there we are in litigation.
Assume that there's a material breach. Why should the remedy be that there are no benefits due?
I'm sorry, why shouldn't the remedy be?
Why should the remedy be that there are no benefits due under the policy?
Because I'm saying that there's different types of conditions in policies. And the reason that I'm saying the critical things here, and in every one of the cases we're asking you to follow, including the uninsured motorist cases, albeit not from this court yet, but are if the insured willfully refuses to comply with a condition, and the condition is one of the ones, and there are only three really, where the only person who has the information is the insured, and the only one who can provide it is the insured. We have these conditions designed before a suit's supposed to be filed, and hence the no action clause, so that let us get the information, and if we can settle your case and should settle your case, like here where it turns out she has RSD, she tells us that, we wanted to confirm it. We didn't get to confirm it till a year later. But our position at trial was not she doesn't have RSD. There was a question about whether it was caused by this accident, but that's because RSD is a difficult diagnosis and it's a difficult causal relationship. But The doctor that we had, Euricchio, is an RSD specialist, and if we had had our chance that our policy is designed to give us to resolve this before, then none of us are here. She gets the $100,000 that she paid the premium for. We're done with the whole thing.
If State Farm is defending under a liability claim, does State Farm assert that it has the right to require that third party to submit to State Farm's exam before suit is filed?
No, not
on the liability policy.
And
where is the condition in the statute that says that you cannot file an uninsured motorist claim until you comply with a medical examination requested by an insurance company?
There isn't one in the statute.
Okay. All right.
Okay. But I think that we can fill in with reasonable policy conditions, and I'm telling you that this is a sensible provision that's meant to do, that has a good purpose and a good intention. And the only
where
reason
in the policy,
yes, Your Honor.
Where in the policy does it provide for forfeiture being the consequence of not complying with the CME request?
The policy says that no action shall be brought unless there has been compliance.
Okay.
Until there has been compliance with the policy terms.
Okay, it says that, but where does it say that you're going to forfeit all benefits from the policy unless you comply? It doesn't say that.
That's how that clause has always been interpreted, including by this court, starting in the Southern Insurance versus Putnell case from 1909. That very phrase, that's exactly how it's treated. And I mean, what this court said way back then, and it's how it's been treated by the other cases since, is requirement for an EU, that's an examination under oath, it's not a UM case, but is valid and binding, and a refusal to comply.
There's a difference between coverages that are required by law and those that are not. And there's never been a case, a UM case, that says that the insured forfeits all uninsured motorist coverage contrary to a statute because they don't comply.
There's never been a case that said that, or a Supreme Court case?
Supreme Court case.
Okay, well, but we do have one from the 3rd District, and
well,
we
I
have one from
understand
the
it's an
5th.
outlier. I mean, it's one that doesn't even mention the nature of uninsured motorist coverage, and it uses fire cases and life insurance cases. I'm well aware of those cases.
Okay. Well, the question is...
Well, you as a very, very respected and a very experienced insurance defense advocate and lawyer, you're a great lawyer. Don't you agree there's a difference between fire policies and life policies and uninsured motorist coverage?
I do.
Okay.
I do, but I also think that there are reasons for policy conditions that... And remember that any of these conditions that we have, or any terms of our policies, have to be approved by the Insurance Services Office by statute. I think it's 627-410 or something. We're not allowed to have any provisions in our policies that haven't been.
The issue isn't whether it's a lawful provision. The issue that Justice Labarga asked you, and I'm sure you answered it, where in the policy does it say that the result of not complying is a forfeiture of all benefits? And that's what Judge Lawson was talking about, whether that State Farm was the master of its own contract. So it's not a question of whether it's a lawful provision. Nobody's contesting that. The question is whether even a material breach of it mandates, as a matter of law, forfeiture of all uninsured motorist benefits.
Well, quite separate and apart from what type of policy it is, the language that no action may be brought has been held by this court in the Southern Insurance versus Putnell case. A no-action clause means that if you breach the policy condition in question, then the no-action clause will, if you breach it and file suit anyway, under the no-action clause, you forfeited your benefits for that loss, for that particular loss. But I still, if I may, there's nothing sinister or ill-intentioned about these policy conditions. And
well, let me ask you about just the language. And I understand what you say about Putnell. I actually tried to read that, and I did read it. It's like going into a different time. But the language itself in the policy doesn't suggest forfeiture, does it? Because it is a temporal reference. It says until. Now, that might suggest that the lawsuit gets dismissed, and whatever happens as a consequence of that happens, and then when they comply, then they can file again. But why isn't that language until? Why shouldn't we consider that to be significant?
Well, if you want to recede from or change Putnell, I'm just telling you that that's what Putnell said, and so that's how everybody's been governed ever since. If that's how that condition is interpreted, and it has been, it's because it's otherwise you're just saying it means nothing. It's like the insured just go ahead and breach and file suit, and it's not going to mean anything. You don't have a cause of action against us. You've agreed you won't bring one unless you give us a chance to do our job.
Dismissal of the lawsuit would not be nothing. I understand your view that you suffer prejudice once the lawsuit is filed because you've been dragged into court without the compliance with that condition, which is a prerequisite to their ability to file suit.
Correct. And so there has to be some consequence for them filing suit anyway. And if it's not going to be, what it is you do it at your peril. That's exactly what this court said in Putnell. If you want to just stand on what you think your rights are and file the suit anyway, then you do it at your peril. But here, if we had been given the chance, that's really the point is, you insured are the only one who has the information. It's like examinations under oath for that reason. You're the only one who knows the truth of what's in your head. With your physical condition, you're the only one who can give us that. We asked you for it. Your policy says that you will give it to us, and you don't. So if you willfully breach, why are we worried about forfeiture? If you don't want to forfeit, don't create a forfeiture. Just do it. I mean, there's not a problem with. It's not an unreasonable. No one has contended it's unreasonable. We need to know what's wrong with you so that we can know whether we should give you the money.
You're out of time. You'll have 1 minute for rebuttal.
Thank you.
May it please the Court. My name is Gary Farmer, and I'm speaking on behalf of the respondent, and this is Mr. Alpizar with me at the council table. I want to respond to the characterization of the holding in Putnell because, as I understand counsel's argument, she seems to be saying that case alone is authority to impose a forfeiture simply because of the violation of a policy condition. The truth of the matter is that not only is it a fire insurance policy, structural insurance, but the court was at pains at several points in that long-winded opinion that goes through declarations and rejoinders and all of that other stuff that I've long since forgot what it meant. Nevertheless, if you wade through it, you'll see at 2 points in the opinion they point to the specific language of the Putnell policy, which said at the very beginning, no benefits are payable under this policy unless the insured has done this. That is to say, given an examination under oath. It says nothing about a compulsory medical exam. The court cited a mid-19th century United States Supreme Court opinion which talked about the importance of that particular provision in fire insurance policies because of the arson and all of the other things that could go on. So if you really want to read Putnell according to its holding is that where the carrier has taken the time and effort to put into the policy a specific consequence for noncompliance with a policy condition, we will enforce it, even though it means no benefits are payable under the policy.
So they could. Your position is, if they did it, they could do it lawfully and not be in conflict with the uninsured motorist.
Well, that's another story, but we haven't gotten to that. What I am saying, though, is they could have provided another lesser form of remedy for a violation of that than the one that they seems to apply in the policy. Which
why isn't it lesser to say that no action will be filed until that happens?
I'm not quarreling with that. That is, but what is the consequence of filing the action anyway? They could have had some consequence specified in the policy.
What should be the consequence?
The action will be abated or dismissed. You'll pay us the cost of having to go into court and raise this issue.
And what happened in this case?
In this case, none of it happened. They decided right off the bat, the minute that she did not appear for the September 12th CMA and was not going to appear for the CMA on September 12th, their immediate position at that point was reservation of rights, no coverage.
Well, in fairness to State Farm, this wasn't about the $100,000. What was the verdict in this case?
A little over $4 million.
This was about, in my view, both parties posturing for the subsequent case.
I'm glad you said that, because let me agree with you. It is about both parties posturing, whereas the comments of the judges in the 5th District were focusing on only one side posturing. What you have is a result of several changes in both law and procedures and policies. What you have here now is it's an aquatic ballet between sniping fish who can electrocute you, so to speak, if you don't comply with what they want. You have on the one side the insurance company, which went out and got a notice requirement dropped into the bad faith law, requiring that plaintiffs, if they're going to claim a bad faith, they have to give a notice at some special period of time and have to give them 60 days to comply, and that had never existed before.
There's nothing.
No.
There's nothing wrong with that.
Let me finish, though.
Okay. Because you sound like that's a sinister thing.
No. What I'm getting at is the way it's being used and being employed. They then start dropping into their policies the CME requirement. Let me point out something to you. They were doing CMEs in cases and liability insurance cases for a long time in the state without any provision in policies for them, because Rule 1.360 had been interpreted to give them an absolute right to that. That was never a problem. So why are they putting them in their policies and saying you can't sue us until...
Before a lawsuit was filed, if they didn't have it in there, was there an absolute right for them to have it, for the insurance company?
No, there wasn't.
But what is wrong? What is wrong with a provision that allows the insurer to fully evaluate the claim and have a medical examination?
None. I'm not fighting you on that basis. I'm not fighting you on that basis. I absolutely agree with you.
Is it your position that condition in the policy is invalid because it's inconsistent with the uninsured motorist statute?
No, sir. Absolutely consistent with you. But let's talk about this case and what we're talking about. They said, you heard her describe a few minutes ago, that the problem in this case was the particular medical condition, RSD. Difficult to diagnose, doubtful onset, or delayed onset, all kinds of problems with it. Okay. How do they want to do this CME that is so important for them to find out if this is really an RSD case or not? They pick an orthopod 70 miles away who is a shill for carriers doing CMEs.
It seems to me that I'm going to go back to what I said. It seems that both sides are posturing for the
and I agree with that.
I mean, for the bad faith case.
But they're not posturing. They're trying to protect themselves in the event that comes down to that.
Well, it seems to me that everything they've said, which is they try to get this resolved through a medical examination, would be perfectly appropriate to raise.
I agree with that.
And your defense of saying, look, but if they really cared about it, they wouldn't have set it up with an orthopedic surgeon 70 miles away, will be your thing. But here we are.
Right.
Is this provision in the contract a material provision? In other words, is this, if she did not comply, is that a material breach?
What do you mean? What do you mean by material? Is it a breach? It's a breach. Yes.
Okay. So
does it vitiate the entire policy? No.
Under what circumstance would it vitiate the entire policy?
If they had said so. If they had said in their policy that this is a condition to coverage, that you comply with this. Now, whether that complies with the statute, I agree with you, is another problem entirely, but we're not talking about it. What we are talking about is the fact that if they want to make it that serious, that important. Let me go back to basic contract law. What they are asking you to do is take an old contract principle that where you have mutually dependent promises for performance, the breach of the one releases and discharges the other. That's what they're trying to say, that this is that kind of a condition in the policy.
On the question,
almost one that precedes the policy.
On the issue of posturing, the setting up for the bad faith case. In the personal injury world, the clause in the contract that provides that State Farm can have as many CMEs as they want, is it common practice in the personal injury world for lawyers to negotiate on that and say my client will appear for one if you give up the other ones, or is that commonly negotiated? Or
not only is it commonly negotiated, your opinion in Custer, discussed at length in my brief, says specifically that, and it talks about the problems with CMEs creating problems for both sides. It's not just a one-sided problem. It's not just the insurance company's problem. It does create problems for patients. You have it in vivid living color in this case. If their UM benefits policy was dependent upon finding out whether this woman really has RSD, why aren't they asking her to go see a neurologist and somebody close to where she lives in Brevard County, not way up in the northern part of Orlando? Why are they doing it that way? I can understand the rush to do it too.
Is this really a matter of whether or not, by not submitting in a timely fashion, as she would say, to the CME, that you're losing your entire benefits, or is this a case where you look at this as to whether or not there was some reasonableness in her failure to do so?
I think it's the latter. I really do. Because the truth of the matter is, if you ask me, if they wanted to set that up as a reason why they shouldn't have to pay benefits, they would have to plead it as an affirmative defense, which is the ordinary contract rule of law, that, you say we had this condition in our policy, you didn't comply with it, we plead that as an affirmative defense, and at that point they have to show some prejudice from it. We then have the opportunity to show, there's another side to this. What we were asking for was reasonable.
But in this case, it seems to me, and correct me if I'm wrong, your client on several occasions refused to submit to the CME.
Well, I want to be careful about this. No, she didn't refuse to submit. What she tried to do was negotiate provisions, conditions, some agreements. One you've already heard talked about, one time only. I agree that that's probably unreasonable. Okay. In the context, even though this kind of a disease and the 70-mile travel is very hard for her. No, I don't. I'm not going to say on its face that's completely reasonable without more. But the rest of what she was asking for is the kind of thing that this court has approved doing in 1.360 examinations for many years. You said it's entirely reasonable for the patients to have reasonable accommodations, giving in to the idea of a CME. So all of the correspondents here said we're going to do the CME. We're talking about how and where and when.
What are you asking us to do? Are you asking us to send the case back to the trial court level to have an evidentiary hearing to see whether prejudice occurred to State Farm?
No. They forswore that. They had every opportunity in the world to ask for that, and they said no, they wanted breach only right from the very beginning. No, I think the case should be answered. What you should do is answer the certified act. Let me explain something. The 5th District did something I thought was interesting to me about getting this case to you. They certified it as a question of great public importance in an opinion in which they openly said we're disagreeing with the 3rd District's decision in De Ferrari, creating direct decisional conflict on the same. De Ferrari, remember, is a UM case. It's all about a CME violation. It's right on point with this case. So you have direct conflict jurisdiction, but they sent it to you as a certified question of great public importance. I think you should answer the question that in this kind of a situation, we're talking about a condition for performance that not only arises after the contract was made, was not made a condition of all the performance at all on one side or another. It's just a condition, and it arises not only after the contract, but after an accident and after a claim has been made. So at that point, as you say, it's a cooperation kind of thing.
Right. Well,
why shouldn't this be solved by the ordinary prejudice analysis?
So you would say, is it akin to a notice, the notice requirement that Macias is the correct analysis?
I don't think it's as serious as the Macias requirement.
Well, but it's the same. You may not think it is, but as Ms. Russo says, in one case, State Farm may know the accident occurred by any means, but only your client has the means to make sure that State Farm knows the extent of her injuries. So I could posit that it's more serious than a notice.
Which, as I said, involves a disease that only manifests itself later on and is difficult to diagnose. So the delay between the accident and them getting notice of the extent of her injuries is perfectly reasonable and understandable.
So your position is it's a condition subsequent, and that therefore prejudice is the burden is on State Farm to plead and prove that the breach of the duty to submit it was breached and that they had the burden to show prejudice?
Yes, and that we would
prejudice
then
does
have...
enter into it, correct?
I'm sorry?
Prejudice is part of the
They would
analysis.
have to show prejudice, yes.
Now,
And then we would have the opportunity to rebut that.
Now,
and show
what
that.
the 5th District said is that the way the State Farm failed to meet its burden, and as the issue was framed and presented, he properly determined that no forfeiture of coverage had occurred. State Farm made no assertion of prejudice in its pleadings or arguments. And then they said even if they had argued prejudice, the record refutes it because, and then they go on. Do you agree, under Head Note 9 of the 5th District's opinion, do you agree with everything they said about why there's no prejudice?
Yes, I do. Yes, I do.
What if they,
in addition to the fact that they simply waived the whole idea about it, whether they had any.
the determination of the trial itself was that your client was entitled to the $100,000 of benefits.
Yes.
Right?
That was basically what was decided.
It would seem that the prejudice to the State Farm, I guess, had they chosen to assert it, would have been the cost of the litigation itself. Their attorney's fees and
up
costs.
up to the point where they got their CME, which was not that long. And all I'm going to tell you really is they have never suggested that in the delay in doing the CMA change the diagnosis.
It seems like if they're in a trial, that they have to see through the end of the trial in some way, given their strategy and litigation. It's once they're in, until they see a way out.
Attorney's fees, cost of defending. I mean,
so you would disagree that they would be entitled to attorney's fees and costs that's the prejudice piece.
No, I'm suggesting that's a set-off maybe of damages. They could be reduced the $100,000 obligation that they owed the client.
When did the examination occur?
Well, I think Ms. Russo was correct. It may have been about a year after the suit was actually filed, but in the meantime, nobody was pushing to having it done any sooner.
In other words,
anyway.
after the lawsuit, I just want to make sure, after the lawsuit was filed, which was, I thought there
August of 2007, I think.
State Farm, after the lawsuit was filed for a year, did not ask for a...
Once they said the policy was revoked, was over, no coverage, that was their position in the case.
Did they ever offer the $100,000?
Well, that I don't know about.
Prior to suit.
And I'm not sure why I don't know it, but I don't know. Let me just say this. After the case broke down in September of 2007, and they declared that the policy was no longer provided any benefits, it was forfeited, the next thing that had to be determined was the whole question of whether there was a forfeiture of the policy benefits. So we had cross motions for summary judgment. They weren't determined until the following spring, if I remember, March or April. And if I'm correct, I think you're talking the CME was done maybe in August, July, something like that. And it was Dr. Euricchio, and by the way, his report did find there was RSD. I mean, which they didn't use at trial. My point is though, it's inconceivable to me that if the whole purpose of the CME provision about having it done before a lawsuit was even filed was so that they could fix and determine for sure that this was that kind of a case, they weren't prejudiced in the least by it. Not in that sense. Now, in defending, as Judge Kennedy points out, I don't have an argument for that. I've thought about it a great deal. I don't have an argument for it other than to say if you deem that prejudice that a liability insurance carrier had a problem in defending a liability case of some kind, if you think that's a real problem, the only thing it is the cost of the defending.
Mm-hmm. Well, but the point is if they have a contractual right for the insured to take a particular action and the insured doesn't do it, and that causes them to have to be subjected to a lawsuit that they would otherwise have avoided, that's not, I mean, there should be some remedy for them for that. Shouldn't there?
$1. Yes.
Well,
yes,
$1.
There can be a remedy.
Is that meant to be a joke?
No, because
so $1. Because that's their prejudice.
That's a traditional contract remedy for a de minimis breach of a condition.
So this would be.
And I'm saying this is a de minimis breach.
They're sued when they had a right not to be sued until this condition was satisfied.
You're right. They did.
And that's worth $1. That's your position.
I'm saying it's worth nominal damages, is what I'm saying to you. Now, those nominal damages.
You said $1, so you're backing away from $1. That was a joke.
I'm using that as symbolic, not the amount.
Of course, the
I'm not
policy.
trying to suggest
Of course,
that.
the policy could also have stated that if you don't comply, you default or you forfeit any benefit from the policy. We wouldn't be here today, probably.
And as Justice Lewis has correctly pointed out, I believe in the context of the statute, that may not be a valid policy condition. But what we're all trying to say here is, it seems to me, in this conversation is, there are ways for them to have drafted a policy to provide some remedy for this very eventuality, knowing that this is now a dance of the scorpions in all these cases where there does appear there might be significant injuries. That's exactly what's going on with all of them. The plaintiffs are worried about getting knocked out of court because they didn't comply with the bad faith statute and do all the other things that they're supposed to do. They're worried about we're not going to be able to get we need CMEs done. We need them done right away. Now we have a dance where each side is trying to use their thing to clobber the other side with in relation to something that may eventuate next after this case is over with.
Well, I mean, but that's the problem in discussing it in that context. I mean, you guys are fighting about some kind of bad faith, and they may have an absolute defense to that. Yet we are going to make established law for a Florida family that may sustain $15,000. Not some enormous injury,
right.
And a working family and problems with getting to it, a yard worker who can't afford to miss work. I mean, there's all kinds of situations. And when we start overlaying this bad faith stuff on it, we miss the point of the issue that we're here on.
I agree. And I'm not suggesting that you should be doing anything. If you remember my brief, I said at the end of the brief, I don't think that's an appropriate issue in this case, because I thought the issue was straightforward. There's a conflict between De Ferrari and Curran of the 5th District, and it is this. Over this kind of a condition, which has nothing to do with contracting in the first instance or the payment of money damages under the policy, but which has to do with their processing of the claim afterwards in sort of a cooperation kind of thing, what is or ought to be the remedy analysis? And that's all it is. They say the remedy analysis is thermonuclear war. The policy's over with, gone. The world ends under this policy. And we say that's not what your cases say. That's not what Macias says. That's not what Custer says. That's not what Cimino implies in its discussion on the whole CME analysis and how they do this dance under 1360 about, well, I'll go to this doctor if we can do this, if we can adjust this over here and we could agree on this. You've said that's perfectly permissible and understandable. That's all they were trying to do in this case. You read their correspondence right from the very beginning. It was never we won't do the CME. It's where, when, how.
You're out of time. Thank you.
I'm sorry.
I'm sorry. Justice Labarga, you had a question?
No, it's just in how many.
Yes, and how many. I forgot.
Just a couple of very quick points. One of them is that we're not asking for thermonuclear war. We're just asking for the insureds to comply with the policy condition.
Let me ask you a question, because it seems to me that the argument has broken down to whether or not, in my mind, you want a remedy that you could have not validly had if you had actually put it in your policy. Do you agree with their position that you could not have had a policy provision that actually said that you would forfeit your benefits, and that would have been a violation under the statute?
No, I don't. I don't agree with that, because I think that insurers are entitled to put reasonable provisions in. You're asking for bodily injury money. We have a right to find out, well, what's the bodily injury? And let us do it before we get into suit. On the prejudice, we didn't waive any question about prejudice. It's that at the time that we were brought into suit, the governing law was, if you don't comply, all we had was the district court decisions from the 3rd District and the 5th, which was governing. And that's the Kazouris case that followed De Ferrari, that said if you don't comply with your CME, then you have forfeited the policy benefits because you had the chance to do it on time and you filed suit anyway. So there wasn't a question of us having to raise prejudice. We did raise the affirmative defense. And in footnote, I just would like to say that in footnote 6 of our reply brief, I documented the many times that we tried to get this exam after the suit was filed that was blocked by them, including as soon as within a month of them filing the suit, we tried to set we had to now do it under 1.360, and there was an objection filed by the plaintiffs. And it was to Dr. Uricchio, the same one that they had agreed to, And the final point on Dr. Uricchio, just because I'd like this case to be decided on its facts, and this was not game playing back and forth. Dr. Uricchio, and this is at volume 3, page 493, the plaintiff testifying, her own treating physician suggested that she go to see Dr. Uricchio because he's an RSD specialist. That's all we wanted before the suit was filed was, give us a chance, comply with your policy conditions, let us find out what your bodily condition is so that we can avoid involving every court in the state in what should have just been decided. There have been only 3 of these cases since 1993 where the courts have had to get involved, and it's always because the plaintiff refuses to comply. People aren't having a problem with just going for these medical exams. They're routine. They're understandable why they're needed by the insurer. It's only when there's bigger game afoot that this comes up. We would ask that we go back to what the 5th District held in the original panel decision, which is comply with the policy conditions. If you're going to read in a prejudice requirement, it should definitely be on the insured to prove it, just as it was under Macias, because the insured is the one who breached.
Thank you for your arguments. The next case is Raymond James Financial versus Phillips.
May it please the Court. My name is George Guerra. I am here today with Dominique Heller, my co-counsel, on behalf of Raymond James Financial Services, the petitioner in this action, asking the Court to reverse the second DCA and to answer in the affirmative the question it presented.
Now, can I ask you a question about the question? The question presumes that the arbitration agreement does not incorporate the statute of limitations in Florida. Do you agree or disagree with that the contract does not control the answer to this initial question?
Your Honor, I do have an issue with the question, and I do disagree with the proposition that the contract does not incorporate the...
I mean, this is a friendly question. It seems to me that there is a very sensible reading of the contract.
Correct.
That incorporates the statute of limitations of Florida by saying any time bar claims are ineligible for arbitration. Was that argued below?
It was, Your Honor, and in fact, the fact that this Court and other courts of this state have held that language similar to the language in this contract does in fact incorporate the statutes of limitations is one of the primary reasons we believe this Court should.
It would be hard for me to believe that with everything else that's done in arbitration that the intent isn't to give an open-ended agreement to file the claim whenever you so deem, not you, but the agreed party.
Right. And I think that's absolutely correct. I mean, that's one of the fundamental issues that's presented by the Second District's ruling is that there really is no legitimate way to harmonize the notion that the policy or that the intent of Chapter 95.
Well, you keep on you're going back to 95, but so you're saying you still have to decide whether it's a proceeding, whether that is intended by the statute of limitations.
Well, no, actually, that's correct. I mean, we don't have to get there, and I think that's maybe what the point really is ultimately. The contract does incorporate Chapter 95. It doesn't make sense to suggest that if you go to arbitration, all of a sudden you don't have the rights that are part of 95 because the contract specifically says this contract and all the rights of the parties pursuant to it shall be governed by the internal laws of the state of Florida. Chapter 95 very clearly is part of the internal laws.
Well, I guess then we get back to this Chapter 95. Then maybe we do get to the question: does it incorporate arbitration proceedings within the plain language of the statute of limitations?
It does, and I think it's
so maybe it has to. What I guess I'm saying is maybe you have to reach that anyway, because it's only applicable if the state of Florida intended for arbitration proceedings to be subject to the statute of limitations.
Well, and it is a bit circular, but I think if one starts with the proposition that this contract, and looking at this contract, which is I think a fair way to analyze it, does incorporate Chapter 95, does specifically say no claim shall be eligible for arbitration if it would otherwise be, and I'm paraphrasing now, if it would otherwise be barred by the statute of limitations, that is a successful incorporation of the statute of limitations.
Well, doesn't this case really come down to whether, and I'm going to phrase this question carefully, an arbitration proceeding is a proceeding?
I think that's a very fair question, and I
thought
think
you would. Opposing counsel won't like that formulation, but again, when I say arbitration proceeding, I'm not alone in saying that. That's in the statutes, right?
It is in the statutes, Your Honor. This very court has referred to arbitration proceedings in a variety of instances, including even in the Blle decision, which has been the center focus of this case now for some time. In its analysis, the court referred to arbitration proceedings. And so there's no question that an arbitration proceeding is no different in the sense, in the way that the term proceeding is used.
Well, now, and the statute uses the term, does it say action and proceedings, or what?
Or civil action or proceedings.
It does.
Civil action or proceedings. So there must be, doesn't an inference arise that it must be talking about something there when they say proceedings other than actions? There's some distinction in mind, correct?
Absolutely, and a more expansive expectation, really, based on the fact that if it's not that, then, as the second DCA determined, if it's not, if it means the same thing, then it's as civil action, then the court has effectively created a redundancy, or in fact limited the statute in a way that.
Except that it says, let me read the rest of it: a civil action or proceeding, called action in this chapter. What does that mean?
It means that it has now, from that point forward, defined an action to include any proceeding as well.
Okay, so there's not another place, but aren't there places in the Florida statutes where arbitration is referred to as a proceeding?
There are. In fact, one is the Florida Arbitration Act. And in fact, to read those in harmony, one would have to conclude that clearly arbitration proceeding, or proceeding means arbitration proceeding, just as Justice Kennedy suggested.
Okay, so tell me this. Where is it that the second district went wrong in saying that the statute of limitations were not applicable to arbitration claims? What is the flaw in their reasoning that where they went wrong?
Well, I think they went wrong in a variety of places, to be quite honest, Your Honor. They failed to do what we did when we first began, which was to consider the language of the contract itself and to conclude that it specifically incorporates specifically incorporates the statute of limitations. They, I don't think, considered correctly the notion that incorporating the term judicial before the term proceeding actually did limit the statute, and as a consequence impermissibly changed the meaning of the statute. We also believe that the second DCA didn't properly consider the legislative intent or determine what the legislative intent was, and harmonize or effectively determine how it was that the legislative intent behind Chapter 95 could possibly be different when parties appeared in arbitration versus in a state court or a federal court proceeding.
This is this a national contract or just a Florida arbitration agreement?
Well, in fact, Your Honor, this contract is now so old, I'm not sure it's either, but ultimately, I do believe that this is a contract that is used throughout in different parts of the country.
Except that it says Florida law applied?
Correct.
So they wanted everybody arbitrating in the United States was going to be subject to the interpretation of Florida law?
Well, I think that the answer to that is probably yes, Your Honor. Whether or not that is today an enforceable provision, of course, this goes back some time. Not only has the law evolved, but the company is a Florida company, and the company's presence largely exists in Florida. Now that's not true anymore, but it was.
So because I was going to ask you, around the 50 states, do other states have a statute of limitations that specifically refer to arbitration proceedings in their statutes of limitation?
There are some, and in fact, the statutes vary. And the second DCA relied on the Washington statute and a Washington decision, the Broome case, and effectively seemed to rely on that. Now, one of the fundamental problems was in relying on Broome and any of the other states is that those states do have different statutes. The only one that we've identified that has language similar to the Florida statute is the Pennsylvania statute, and the one case that we found that actually treated this issue actually found as we believe this court should find, and that is that a proceeding clearly encompasses an arbitration proceeding.
We have had many cases recently that talks about the supremacy of the Federal Arbitration Act. Is there any, what are the implications for the federal, anything as far as how we interpret this, whether the statute of limitations applies or doesn't apply, that conflicts with the Federal Arbitration?
Yes, Your Honor, there is. And specifically, it involves the congressional intent behind the passage of the Federal Arbitration Act. The Congress passed the Federal Arbitration Act in order to ensure that there was no longer the historical hostility against arbitration that once existed. And the case law that has followed has clearly found that when any statute or law conflicts with that objective, then it is preempted by the Federal Arbitration Act.
There isn't anything specifically that has been ruled on that says, for example, if the parties agreed that it was open-ended, that the arbitration could be filed at any time, that's not contrary to federal law, is it?
No, it wouldn't be. But what is contrary is the notion that the rights of the parties in arbitration are different than the rights of the parties are in a state or federal court. And that fact makes it, and because this is, of course, a contract that involves interstate commerce, that makes it violative of the Supremacy Clause, and also it preempts the Florida statute.
Well, in our normal, I don't know if you can even answer this, but generally in these agreements that call for arbitration, and they specify one state law over another, is there normally or generally a separate provision about statute of limitations?
Ordinarily not, but of course, Your Honor, I don't pretend to know what all of the contracts say, and of course, this contract involves a financial services institution, but of course, second DCA's ruling addresses all arbitrations in the state of Florida.
But in this agreement, there is a separate paragraph that actually talks about statute of limitations, and so what is the purpose of that? We have the section that says that Florida law is applicable, and then you have that section D, which specifically talks about statute of limitations, and so why was that section of it necessary if we already are talking about Florida law is applicable?
Well, I think it relates to the presumption that the parties entered into the contract with, which is not only that the substantive law of the state of Florida applies, but that specifically the statutes of limitations are not intended to be preempted, waived, or otherwise changed by any language of the contract. And I guess the other important point is that that provision has no meaning if, in fact, the statutes of limitations don't apply, because clearly there would be no reason to include that provision.
Doesn't it also include the determination that a court rather than an arbitration panel will be making this very decision?
This contract actually gave the option to the parties, and if either party chose to exercise, and I should say in this case the respondents, the claimants in the arbitration, exercised that provision. But it doesn't change the fact that it is a decision that ought to be made. In other words, that the statute of limitations apply, just who gets to make that decision.
Would you respond to the argument, I'm not sure I understand it completely, that Raymond James, in the brief of the respondent, opted for a dispute resolution process with its own limitation period. The arbitration clause required parties to submit to the rules of the FINRA, an arbitration sponsoring organization that has rules which contain a 6-year period of prescription of their own. What is your argument on, or your response to that?
The Financial Institution Regulatory Authority, formerly the NASD, has a series of has its own rules for the conduct of arbitrations, like the AAA has its own rules and other arbitration organizations. FINRA's rule includes a 6-year eligibility provision, and the argument has been made that that eligibility provision is a statute of limitation, maybe agreed upon or self-imposed statute of limitations. It's not. It merely states that a claim is no longer eligible to be arbitrated under their rules after 6 years. It does not affect the statute of limitations. In fact, the rules also require that if a party objects to arbitration of the claim, they cannot object to that claim then being brought in court later. I see that I'm out of time, so I will cede the podium. Thank you.
May it please the Court, I'm Robert Pearl. I represent the respondents in this case, and I find it fascinating that we are here today discussing statute of limitations in an arbitration case when traditionally this Court has ruled that that is the province of the arbitrators. And so we are now in a position where the Court is asked to declare what the Florida law is, where normally arbitrators...
Doesn't the parties' agreement say that?
Excuse me?
That you take this... Doesn't the parties' agreement say you take this issue to a court, that you can, either party can take this issue to court?
Yes, and that's why we're here, because ordinarily arbitrators would make that ruling, as the Court pointed out.
So why is that odd? If Justice Quinn's just told you there's a provision in your own contract, you're not saying we don't have proper jurisdiction to consider this, do you?
Clearly. This is extraordinary because this is the only way this issue could come before the Court, is my point. That typically the Court defers.
It's refreshing, I'd say.
Yes.
It's refreshing that we should be able to declare what the law of Florida is on Florida law claims.
And that is one of the reasons why this is such an opportunity for the Court to declare the state of the law for the benefit of all of the litigants or arbitration participants throughout the state. Otherwise, we are left with some lower court interpretations or no interpretations, which arbitrators then have to determine whether they are bound by or not bound by.
That's a good thing.
It's a good thing.
You just want us to affirm the second district.
Clearly,
you would like it if we agree with you, but
clearly. But I'm also asking the Court to do what the Court has announced is its policy, which is to enforce the agreement according to its terms. And what we're asking the Court to do is declare, as the parties have agreed in this contract, that the Court will determine the applicability of the statute of limitations, and that's why we're here.
Well, I don't know that anyone disagrees with that.
No, and I'm making that observation because I think it's helpful to understand that this is a matter of contract. The appellant has argued that to affirm the district court decision would be anti-arbitration, would reflect a hostility towards arbitration, which would be against federal policy.
Well, let's just look at the language of first of all, the contract, but you may disagree on whether the contract plainly incorporates Florida statute of limitations. But I'm having a hard time understanding how civil action or proceeding does not include from a reasonable reading of the term, an arbitration proceeding. I'm having a hard time to believe that anyone that knows the history of arbitration would think that somebody entering an arbitration agreement gave a plaintiff free rein to file the arbitration anytime they wanted, as opposed to within the statute of limitations.
And that is why the contract terms are so essential, and that's why the district court framed the question the way it did, which is, can it be implied? Can it be inferred by the terms of the contract? Here, the DCA established the certified question as, do the parties have to expressly incorporate? The DCA also said that this contract does not do that. That, in fact, if there's any confusion as to the meaning, it's construed against the drafter.
You do
Raymond
agree
James.
that it's an issue of law for de novo consideration by this court?
Yes, I absolutely agree.
So we can disagree with their interpretation of their contract and the interpretation of the statute. So just let's focus in on the statute. Tell me why action or proceeding does not expressly, plainly include an arbitration proceeding.
And that is the heart of the question, because if this court determines that the language proceeding in 95.011 does not include arbitrations, we're done in this case, as far as we believe. And it does not include proceedings. We've gone at length to explain the legislative history here, the fact that there is no record at all of the term arbitration being considered by the legislature when the statute was reviewed and the law revision.
You've got a term, proceeding. And I'm looking here at Merriam-Webster's Dictionary of Law because that's what I happen to have on my iPad. And it says, proceeding, a particular step or series of steps in the enforcement, adjudication, or administration of rights, remedies, laws, or regulations. Now, an arbitration would seem to come clearly within the scope of that. That's what an arbitration is. It's a series of steps or a step in the enforcement or adjudication of administration of rights, remedies, laws, or regulations, depending on what the subject of the arbitration is. Why isn't that plain meaning? And the meaning of it here is not, in this particular dictionary, is not going to be that different than in, I think, probably in Webster's International Dictionary or any series of dictionaries. So tell me why, given that plain meaning, that accepted usage of that term, the Second District could possibly be right in the way they've interpreted it.
Because the term proceeding, as defined as you've just identified, is only one definition. In fact, the Florida legislature has defined the term proceeding differently. We've set
but they've
forth
referred to arbitration proceedings.
No, they've used the term proceeding in Chapter 92 as meaning any civil or criminal action before a court.
In the Arbitration Act, are there not references to arbitration proceedings?
And I'm glad you raised that point, because
when
they talk about
but if they're referring, if the legislature itself and the Arbitration Act is referring to arbitration proceedings, how can you possibly take the position that an arbitration, what is it if it's not a proceeding? An arbitration
is a contractual effort to resolve a dispute. And it could be as simple as Mr. Guerra and I agreeing to appoint Ms. Heller to resolve a dispute. We could have an agreement on a piece of paper, and we would say we appoint her the arbitrator. Now, does that itself constitute a legal proceeding or a proceeding under the statute?
Well, the legislature must have thought that arbitrations, what happened in arbitration are arbitration proceedings because they referred to it as arbitration proceedings. Am I wrong?
Yeah, because in the arbitration code, the term civil action or proceeding is used, and it's used to describe the proceeding to either enforce or to vacate an arbitration ruling in court. That's where it's found. And it is not intended to...
So they never actually refer to arbitration proceedings.
No, they use the term arbitration proceeding as the in-court proceeding and not a separate private resolution, dispute resolution. I think the context here is also important in that this agreement is an industry agreement. Mr. Guerra and I practice in the world of FINRA arbitration, and the difference between arbitration and court is pronounced. We don't have normal appellate rights. Great deference is given to arbitrators. We don't have jury selection. We don't have normal discovery. The rules of evidence are relaxed. There isn't normal motion practice.
I guess and the point of all of that is that everything that a victim of securities fraud, if they agree to arbitrate, have are lesser rights than somebody would have in a court of law. It sounds to me.
That is correct.
So now you're saying the only right that actually you have greater rights than if you were in a court of law is that you can bring the action anytime you want.
No, and that is because Mr. Guerra responded to your question, Your Honor, regarding the 6-year eligibility rule. When this contract is drafted by Raymond James, there is in the background a 6-year eligibility rule. And eligibility for arbitration means that if it's not brought timely, then you can be dismissed in arbitration. But according to the NASD arbitration code at the time, there is then a concomitant right for you to launch a lawsuit. You and the parties agree by this code of arbitration that the lawsuit can be brought without prejudice because you brought an arbitration, but then that's governed by the statute of limitations. So there's a fallback. And the drafter of this agreement knows that, so that when this a unique agreement is prepared, it's done in the context of FINRA arbitration, just as though the parties can incorporate a longer or a shorter statute of limitations by agreement. There is nothing in the legislative history here that evinces an intent by the legislature to include arbitration as a term intended to be covered by the word proceeding, and it is just as likely.
If you're correct, then it seems to me, why would you need to have both the word action and proceeding? Because if you're talking about something brought in a court of law, to me, action would cover it.
Because
so
action,
why do you have the two terms? You seems to be writing that proceeding out.
Because action is a term that means a lawsuit by a plaintiff against a defendant. A proceeding traditionally is something that can be administrative.
There are two parties in the proceeding also, right?
Excuse me?
There are two parties in the proceeding also, correct?
Yes, and there's illustration that Chapter 95 provides, such as proceedings brought by municipalities or government agencies and so forth. So the question is, by including the word proceeding, and we've given the legislative background here, is there any indication that the legislature intended that to include all arbitrations of any kind anywhere in the state of Florida?
So
and there's nothing to suggest that.
Why would it be excluded? I mean, it just seems to me that there's no delineation of everything that's included in that word, and the mere fact that arbitrations may not have been mentioned does not mean that arbitration is not included.
Because this court's role with respect to statutory construction is not to add language that the legislature forgot to include.
It just seems that, I guess, that the Washington case that you rely on, the statute of limitations, in that case, specified actions only.
Correct.
So actions or proceedings in normal statutory construction indicates a broader application. And are you so what is your argument as to what proceedings mean? It only applies to what?
It applies to judicial proceedings,
well, isn't that
civil
an action,
proceedings.
in section 682.07 in the Florida Arbitration Code, it says a party has the right to be represented by an attorney at any arbitration proceeding or hearing under this law. A waiver there prior to the proceeding or hearing is ineffective.
Okay. And that is clear, Your Honor, that the legislature knows how to use the term arbitration proceeding when it intends to include that within its definition. Here, it didn't use arbitration proceeding.
So you're saying it had to include the word arbitration in the statute of limitations?
And because it didn't, were this court to do that, it would be in effect adding statutory language.
So if somebody had
to,
what about an administrative hearing? Somebody tries to initiate an administrative hearing that's outside the statute of limitations. They got to include that too?
Well, that's the problem with using the term proceeding to mean just about anything.
Well, it's not just about anything. It's some kind of legal proceeding. I think in the words used by the legislature, by case law, I think arbitration, whether in federal or Florida law, it's common to refer to arbitration proceedings as just that. That's what they are.
And if that was the legislative intent, that we would know that. In fact,
it says right in that statute that the Chief Justice just read to you, the legislature is saying that what happens in an arbitration is a proceeding. By putting those words together, they don't have to put it in the statute of limitations. Also, I
respectfully disagree.
It mystifies me.
Yeah, I respectfully disagree. In fact, in this court's decision in the Blle case, looked at the legislative purpose behind the statute.
But there's nothing ambiguous about the term proceeding. Why is that an ambiguous term in this context?
Because arbitrations are not proceedings. They are the private
whole world
enforcement.
Says that they are, but you say they aren't.
Well, they're not according to the normal parlance, and there are different definitions, such as the one I just read, which doesn't describe it as arbitration at all.
Okay, you said something earlier that anyone could contract to have a shorter statute of limitations.
Yes.
Are you aware of 95.03
Yes,
that says that you cannot set a lesser time than provided by the statute of limitations, that it's void?
And that's correct with respect to any action. The language action appears right in that statute.
Then so you think that it could be they could set a shorter statute of a shorter time in the arbitration proceeding and it not be an invalid proceeding.
The parties can agree by contract. It's a question of whether the court wants to enforce contracts by their terms.
You keep on mentioning that about the legislative history. Prior to 1974, there was no 95.011. 95.03 was limited to apply only to suits. We would agree suits is a more narrow term, correct? Suits.
I'm not sure that there is a distinction between suits and actions in my experience, Your Honor. An action is something that is commenced by a plaintiff. A proceeding is typically commenced by a petitioner.
Which is
and a suit is also commenced by a plaintiff.
Your idea is that this statute only applies to something brought in court.
Civil action or proceeding, we believe, means a civil action or a civil proceeding, and therefore it would apply to something in court.
And if somebody wants to narrow it, then they must do it by contract.
Two ways, Your Honor. And once again, this is the irony that brings us here. Raymond James had the ability to specifically incorporate the statute.
And I will say that I actually thought they did that, so that's not helpful to you, but I thought that's what they did in their contract.
I think the DCA said that they didn't by express language.
And I
we
think
believe
they
that when
did.
they incorporate the law of the state of Florida, and you asked a pertinent question, that is this contract supposed to apply nationally, and it is a national application contract. There is no reason to conclude, we believe, that by referencing the law of the state of Florida, that you're referencing laws that don't apply to arbitration. And that it's circular, as Mr. Guerra pointed out. We don't believe that there is an express incorporation. And one only needs to go on the internet today to see that there's already suggested language to remedy this problem that's been promulgated by prominent law firms in the state of Florida. If you want to make sure that your arbitration contract includes the right to raise the statute of limitations as a bar, put it in your contract.
But didn't they do that here?
They did not do that here.
But what does subsection D mean? I mean, subsection D says, nothing in this agreement shall be deemed to limit or waive the application of any relevant state or federal statute of limitation, goes on to talk about making that determination in a court. So what is the point? I mean, if
the point is that if there is an applicable statute of limitations, they want to be able to raise that in an arbitration hearing, but it has to be applicable. There are two states, I think Justice Parental mentioned this to Mr. Guerra. There are two states that specifically have adopted arbitration codes that state that the statute of limitations apply in arbitration. That's New York and Georgia. Both of those statutes were on the books when the Florida legislature enacted 95-011 and chose not to do that. And therefore, we believe that for the court... If
you're going to draw an inference about the intent of the Florida legislature based on their failure to do something that some other state did, I would suggest that's pretty fanciful, because I don't think people in the legislature are necessarily consulting what the law of other states would be when they're enacting the laws of Florida. They might incidentally do that, but that's not something that we would charge them with knowledge of.
And that is why we supplied the court with the research we had done with respect to the legislative history. Both us and PIABA, in its amicus brief, referenced the fact that they had listened to the audio tapes of the legislative deliberations and indicated there was no mention of the term arbitration. And for this court to determine that arbitration means proceedings essentially opens a Pandora's box, or reverse that. Proceedings means arbitration, because that means that all types of proceedings are now subject to all of the provisions of the Florida statutes.
And why not? Because it seems to me that the legislature could have easily said court proceeding, just as they said, an action we know is a court proceeding. If they were limiting it to just court proceedings, that could have easily been done. So why? I mean, I'm just not sure.
The Pandora's box means that, for example, the Florida Evidence Code now applies to arbitration. That all of the substantive laws of the state of Florida, even in the absence of express language, now are incorporated into the arbitration proceeding. And that's not the nature of arbitration. Arbitration is intended to be expeditious, unlike this case, of course, where we're now 7 years post-filing and we're still talking about it. But I don't think that that's the legislative intent, and I don't think the role of this court is judicial legislation. I think it's interpretation of what the legislature had in mind back in 1974. And I don't think that there's any indication that they intended arbitration to be included under Chapter 95 under the term civil actions or proceedings.
So if for some reason some other kind of proceeding is developed at this point where we could resolve disputes in some other type of proceeding other than arbitration, it would not be covered under the statute of limitations.
We frequently engage in mediation as an alternative dispute resolution mechanism. Does that mean that statute of limitations applies to mediation? You can't mediate the case if it's past a certain period of time? I don't think that would have been within the legislative intention either, and there's many different forms of ADR, as the court is well aware.
You are now out of time. Thank you
for your attention.
Justice Quince, to just pick up on that point, I think that it is a fact that those rules that Mr. Pearl referenced would never apply. I mean, this notion of this Pandora's box that somehow either in mediation, well, let me first address the issue of mediation. In the case of a mediation, Chapter 95 claims would not be brought. One doesn't bring claims in mediation, period. The notion that rules of evidence or other rules of procedure of the state would inherently now be applied is also a false premise. Parties are free to incorporate whatever rules they want in their arbitration proceeding. In this case, they agreed to arbitrate pursuant to the rules of the Financial Institutions Regulatory Authority. They could have agreed to AAA rules. They could have also said, we agree to arbitrate and to do so pursuant to the Florida Rules of Civil Procedure. That's a different scenario entirely, and not one that would be precipitated by a reversal of the second DCA. I believe and I think that it is clear that this contract expressly includes by its language, the statute's limitations. It is also clear that the language of the statute is not ambiguous. The legislature, in fact, has the challenge of creating legislation that may include matters that may arise, things that will come in the future, other types of proceedings, if you will, that maybe they could not have envisioned when they passed the statute. It demands a more expansive view than just judicial or court proceedings, which is the limitation placed on the statute by the second DCA, and we believe that was incorrect. With respect to Section 9503, that is a critical part of the analysis that we did, and one of the fundamental problems with the conclusion drawn by the second DCA. 9503 expressly proscribes the shortening of statutes of limitations. If the second DCA was correct in its analysis, now it's okay to do that. Mr. Pearl referenced the notion that it may be limited by this court or another court's refusal to enforce that kind of a contract. But the fact of the matter is, if that were to be the law, that would never come before a court because arbitrators would be making that decision. And that cannot be, under any reasonable interpretation, an intention that the legislature had at the time that it passed that statute.
Although it does say actions in that 95.03 as opposed to actions in proceedings. So it might be that arbitrators could agree, in an arbitration agreement, to have a lesser statute of limitations because it's proceeding. Or do you disagree with that?
Well, I think potentially parties could, for a variety of reasons, agree to do that. But I also think, and I haven't, frankly, gone through the exercise of considering at what point would parties actually violate 9503 and enter into a contract.
Well, it does say actions, though, doesn't it?
It does, but because the statute, I think, defines actions as any civil action or proceeding, I think it would.
You think it relates back to that?
Correct. I believe that it does. With respect to the eligibility issue, I would simply point out that the issue of eligibility, or that eligibility provision, to the extent that it could even remotely be considered to fill the space of a statute of limitations, that only applies in FINRA arbitrations, which probably fair to say that they comprise a significant number of arbitrations in our state, but that is not all of the arbitrations. Under the second DCA's ruling, as I believe you said, Justice Parental, a party in arbitration could presumably bring a claim forever. There would be no cutoff, and the 6-year eligibility rule would have no impact whatsoever. So accordingly, we would respectfully request that this court reverse the second DCA's decision. Thank you.
Thank you for your arguments. Court is adjourned.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.